Hello.
Ali.
Hello. Hello. Testing. Testing. Testing.
Morning. Morning. Yes.
Wait, please, Your Lordship. Lordship, I beg to mention item 46.
Item number?
46. Will it may be adjourned for the day, Lord?
Why?
My senior is out of station.
Forty-six is a order matter. You wait. Don't make mentions of order matters. We'll see why it is listed. Yes.
Lordship, service have been completed.
Wait for your turn. Yes.
Maybe I will to mention item number 38.
Item number?
38.
Yes.
For CD. CD not received. CD not received.
In item 38, you're right.
Interim is there.
As prayed for by Mr.
A. Islam.
A. Islam lists this matter after 2 weeks on a date to be fixed by the registry. Stop. Interim, if any, shall continue till then.
Obliged.
Next.
May pleasure, Lordship, for listing tomorrow, Lordship. Bail application.
Bail application.
Bail application.
Monday. Next.
Your Lordship, I beg to mention item
Item number?
4.
Yes.
Kindly withdraw this matter. Kindly has instructed.
You just wait. You see, why are you making it making mention for item number 4? It will just come up. Wait for some time. We will see the file and we will give you the order. Just wait for your turn. Yes, next.
Please, my lords. My lords, I pray for the listing of a bail application, if possible, tomorrow.
What's the urgency?
My lord, the person has been in police custody for 10 days and thereafter in judicial custody for over 20 days now. And
all right.
I'm okay.
Next.
Your Lordship, I beg to mention item number 24 of the daily list. Kindly adjourn for the day.
20?
24.
24.
Yes, Lord.
You are MS Espokan.
Yes, Lord.
As prayed for by MS Espokan, learned counsel for the petitioner, which is not opposed by the other side, list this matter after 2
One
weeks.
maybe 14 or 15.
After 2 weeks on a date to be fixed by the registry. Next.
Your Lordship, I beg to mention item number 36.
36.
Kindly adjourn for this.
36 CD is available.
CD not received, man.
As prayed for on behalf, as prayed
M.
by
Doimari.
MS.
M. Doimari.
As prayed for by MS M. Doimari, learned counsel for the petitioner, list this matter after.
On 14th of March.
List this matter on 14/3/2024.
Till that interim protection may be
Interim, if any, shall continue.
If
till
interim
then.
is already there, then my lord on 4th of April. Man.
Next.
Please, Your Lordship, I am praying for list of transfer petition number 923.
Monday. Next.
Please.
Please, Your Lordship, I beg to mention item number 50 for time being.
For time being, you don't make a mention for time being at this hour. What is happening to the bar? Yes. Call for the list. Moitri, 55 to পিছত 52 মাটি দিব withdraw কৰিব খুজিছে। একেলগে কৰিব আৰু এইটো স্ক্ৰীনটো বন্ধ কৰি দিয়কচোন দৰকাৰ নাই। Yes.
I want behalf of Mr. V.K. Goviman.
You have instructions to withdraw. In item number 55, you're right. That your name?
A. Khonikar.
Mr. A. Khonikar, on behalf of Mr. B.K. Gogoi, learned counsel for the petitioner, submits that he has received instructions from his client not to press the criminal petition. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the criminal petition stands disposed of on withdrawal.
Diploma.
নহয় প্ৰিণ্টটো বন্ধ কৰি থলে একো নহয় তাহাঁতক মাতি কানেক্ট কৰি দিব Yes, 56 withdrawn. The same order in 56, but your name?
A. Paul.
A. Paul. Mr. Borthakur, you are appearing in both matters.
Yes, ma'am.
So you record the presence of Mr. E. Borthakur, I mean APP Assam.
With liberty to approach the court.
In 56, withdrawal allowed with liberty. Yes. You want to withdraw?
Yes.
Your name?
S. Rasbunsi on behalf of case.
MS?
S. Rasbunsi.
S. Rasbonsi on behalf of
Islam.
Mr. J. Islam submits that that they have instructions from the client not to press the bail application. Stop. Accordingly, in terms of the aforesaid endorsement made by the learned counsel for the petitioner, the bail application stands disposed of on withdrawal. Screen to বন্ধ করে দিব পারা না? Yes.
Get the petition.
376D and 506.
Yes.
What about status report? No, there is a reminder calling for the status report.
Kindly peruse the office dated 4/3/2000.
4-3? Yes. Received by the registry. Have you seen Mr. Gorthakur?
No, my lord, as per his statement, the victim statement not yet recorded. This is a case of 376.
Victim statement is not recorded.
No, Lordship.
Then we'll.
My lord, at this stage, my lord, this is not a fit case for bail, my lord. Already such a case, my lord, case is registered in the year 2020. My lord, till 23, my lord, he is fleeing from justice and he was arrested only on 19/6/23.
19/6/23.
23. And now case is pending before, my lord, session court.
Trial has started.
Trial, my lord.
Yes, Lordship.
Yes, started.
Trial started. But victim statement is not yet recorded.
Not yet recorded.
This is the case, Lordship, of 376. POXO is not there, Lordship. Lordship, may I place the
376?
deposition of PW1, Lordship?
Yes, where is it?
While victim statement not yet recorded, my lord, at this stage, my lord, case of 376D and 506.
What is this?
Lordship, the deposition of the informant. On the last occasion, Lordship, both the informant as well as victim were present before the
But
honorable.
you see, the informant has become hostile.
Yes.
Victim statement is yet to come.
Yes.
Next date is fixed 2nd of
Page 12 is the FIR, my lord. From old, there was a relationship, admittedly. Also alleged there was a relationship.
Yes, Mr. Borov.
Let him record his statement and, my lord,
He doesn't even have any. Senate counsel
but
for
my lord,
the.
problem is that, my lord,
He has not mentioned in the FIR any which we are concerned. You have to also heard Mr. P. Borthakur, Leonard APP's petitioner, i.e. before, in connection with section 376 of the by on 1/2/2020 last 1 year 12 from where which station? Gauripur.
Gauripur, my lord, on 19th, my lord. Because already 14, 15, my lord, many cases are already fixed.
Take us. Alpha CD list on 19
19.
3/2020. Yes. None appears for the petitioner when the matter was called. Stop. List this matter after 2 weeks on a date to be fixed at the registry.
Wait, please, Your Lordship.
Yes.
Lordship, this petition, Lordship, only for limited prayer, Lordship, am I allowed to appear before the court, Lordship? Here, Lordship, FIR, Lordship, will find on page 29, Lordship. NDPS, Lordship, case is registered under
This
21.
is an NDPS case.
NDPS case, but he
Page,
was,
page.
Page 29, Lordship. Lordship, 21B and 29, Lordship. Then he was arrested, Lordship, released on bail, Lordship. After release on bail, Lordship, he has appeared, Lordship. Thereafter, Lordship,
Go slowly. Why are you in such a hurry?
Sorry, Lordship.
Yes.
FIR on page 29, Lordship.
Yes. And then you were granted bail when?
The bail was granted, Lordship, will find on page 31, Lordship, 10/9/2020, Lordship.
31.
Yes, Lordship.
And then?
He appeared, Lordship, on 11/1/22, Lordship, on page
11?
33. 11/1/22, Lordship.
Yes, appeared.
Yes, Lordship. Thereafter, Lordship, he become defaulter, Lordship. Now, Lordship, he is willing to appear before the court, Lordship, and contest the trial, Lordship.
Which is the order you are challenging?
That order, Lordship, will find on
NBWA?
Yes, Lordship.
Yes.
Page 22, Lordship. 11.122, Lordship.
Page?
Page 22, Lordship. And the certified copy Xerox, that is on page 23, Lordship.
Yes, Mr. Borthakur?
Otherwise, my lord, from 22/8/22, my lord, he has not appeared before the trial court, for which, my lord, again NBW issued.
Yes,
Let him appear before the
He's
trial
assuring he will appear. So if he appears,
earlier he appeared, my lord.
we will set aside this subject to the condition that he appears on the next day.
Yes,
Isn't it?
without any failure. All
Sorry?
subsequent, in all subsequent, he should present before the trial court.
Yes.
Yes, sir.
Heard Mr. B. Chaudhary?
Yes, Lordship.
Mr. B. Chaudhary for the Learned Counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, Learned APP, Assam. This is an application under section 401397, read with section 482 of the CRPC 1973, praying for setting aside and quashing of the impugn orders dated, to me, cost title not power, page 1 11/1/2024, 8/11/2023, 21/8/2023, 26/2023, 2/5/2023, 4/3/2023, 27/1/2023, 25/11/2022, and 12/8/2022, passed in NDPS case number 121 of 2021, corresponding to Gorchuk Police Station case number 366 of 2020, registered under section 21B/29 of the NDPS Act 1985 by the learned additional session judge number 5, Kamrup within bracket M, Guwahati, thereby issuing NBWA against the petitioner and another co-accused, MD Farooq Khan. Stop. It appears, change para. Then you say, the facts of the case is that the petitioner was arrested in connection with the aforesaid case, and thereby he was released, he was released on bail by order dated 4/9/2020.
No, Lordship. 10/9/2020.
10/9/2020. 10/9/2020.
Yes.
10/9/2020. Stop. Trial has, thereafter trial has commenced. Stop. However, the petitioner, after initially appearing before the trial court, started defaulting before the learned trial court. Stop. Accordingly, by various orders dated so and so, NBWA was issued against the petitioner. Stop. The Mr. So-and-so, learned counsel for the petitioner, submits that the petitioner is willing to cooperate with the ongoing trial and appear on all dates. Stop. Mr. P. Borthakur, learned APP, submits that if the petitioner appears regularly on all dates fixed from time to time, he has no objection to the prayer made in this criminal revision petition. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. In view of the endorsement made by the learned counsel for the petitioner, to the effect that the petitioner is ready and willing to appear regularly on all dates fixed time to time before the trial court, this court is of the considered view that this petition can be disposed of with the direction to the petitioner to appear before the trial court
Within 15 days.
Within 15 days, and subject to such appearance, the orders dated so and so shall stand suspended.
Regarding Lordship, bail, Lordship, he he may be allowed.
We are not saying anything. Stop. And then you say this with the aforesaid observation and direction, this petition stands disposed of.
In the meantime, I may be protected, Lordship, till 15 days.
In the meantime, till 15 days, he shall not be arrested.
Highly obliged.
Yes.
Against the order upholding the order dated 31st and I act.
Yes. Where is it? Which page?
Page 40.
Page 42.
Yes, Lord.
Will issue notice here.
Yes, notice.
No, we are giving a short date. Let.
Instead of because of order
We are
already.
not going to stay the proceedings right now.
Simple imprisonment 6.
Your name?
Are wrong, my lord.
Heard Mrs. R. Rongmai, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, Learned APP, Assam. Stop. This is an application under Section 397, read with Section 401 of CRPC 1973, filed by the petitioner. Assailing the judgment and order dated 9/1/2024, passed by the Additional Session Judge within bracket FTC, Kachar Silsor in Criminal Appeal Number 02/2022, dismissing the application filed by the petitioner. Stop. Let notice be issued returnable within 2 weeks. Stop. Mr. P. Borthakur, Learned APP, Assam, accepts notice on behalf of respondent number 2. Extra copies to be served within the course of the day. Stop. Notice in respect of respondent number 1 by registered post AD within a period of 2 days. Stop. List this matter after 2 weeks on a date to be fixed by the registry. Interim prayer shall be considered on the next.
Made. Passing order of framing charge or
Framing charge?
Entire proceeding. Entire proceeding.
All right, then we will issue notice at this stage.
But you will find the material collected. The informant and her mother is the only witnesses. The charge sheet has been filed.
Scan copy of LCR may be called.
No case is made out.
Let them appear, and then of course we will consider interim relief.
Next date is fixed on 30th of March.
So we'll have it before that. All right. Heard Mr. Z. Alam. Mr. Z. Alam, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, Learned APP, State Assam. Stop. Here state is there. Yes. Here state is number 1. আৰু private respondent number 2. একে order to কৰি দিবা খালি এটা returnable 2 weeks নকবা মইত্ৰী এটা date দি দিয়ক after 1 week
on my lord 27 already fixed on 30th of March and 27th of March.
27 March returnable to 27 কৰা
scan copy of LCR and case there.
আৰু লাষ্টৰ ফালে কোৱা let the scan copy of the
LCR and CD.
LCR along with CD be called from the court. From which court?
Lordship.
From the court.
Judicial Magistrate First Class.
From the court of Judicial Magistrate First Class. Nagaon to the registry. Stop. Our list accordingly.
Prayer for interim
prayer to consider next.
Much obliged.
All right. Yes, 11. NDPS.
Well, the fact is something different. Well,
something different, yes. What is different?
But the case is registered under section 21 of NDPS Act. And well, what happened, my lord?
You want quashing of the FIR?
No, my lord. Just one order of the learned...
page 20 order. Page
22.
22.
The first, my lord, when the petitioner was arrested, my lord, he was in jail. And case is the investigation stage, my lord. And on 11/12/2023, page 22, the petitioner filed an application before the learned court, my lord, that he has found, my lord, the HIV positive in the jail, my lord. Accordingly, a bail petition was filed on behalf of the present petitioner. By order dated 11/12/2023, the learned judge may not allow the interim bail. The petitioner and my lord, with a condition, and he explained, my lord, how the positive was found, my lord. Everything explained in page 22 and page 23, and my lord, allowing the interim bail and directed him, my lord, again physically present on 26/12, page 24, my lord.
Yes.
Page 24, last line.
Violation.
Ibn Ahmed directed to appear before the court physically on 26/12/2023.
Yes.
Next page, my lord, order dated 26/12/2023, page 27, my lord. The case is fixed today for physical appearance of accused, also before the court. But
He did not appear.
But the advocate was appear with medical report, and the court was extend the interim order till 11/12/2000. Sorry, my lord, 10/1/2024.
Yes.
Next page, my lord, 31.
Yes.
10/1/2024, my lord, the accused, my lord, the physically present.
Yes.
And last paragraph, my lord, also seen the petition so-and-so, whereby the accused so-and-so personally present in the court today on the strength of interim bail granted by order dated 11/12/2023, and also filed some medical document regarding the treatment and referred to Dr. Olive Hospital and Research Center, referred to the higher center.
Where are you reading from? Which page?
Well, at page 31, my lord. Page 31, my lord, last paragraph.
Yes. Yes,
my lord,
yes.
he physically appeared
Yes.
as per direction of the London court, my lord, and filed the petition. And
So what happened?
my lord, his bail again extended, my lord,
Yes.
and fixing on 24/1.
Yes. Then
24/1, my lord. Sorry, my lord, not 24/1, 31.
yes.
30.
Yes. When you failed, show us that order now. You have failed to appear, and
Yes,
that is
ma'am.
why
Yes,
your
ma'am.
bail has been
Yes.
cancelled.
Yes, ma'am.
Yes. Where have you failed?
Yes, my lord.
Which is that
page-
order?
Page 33, my lord. Page
The type
33.
copy?
Type copy, my lord, that is page, my lord, 20.
Which is the order dated 7/24?
No, my lord.
Then
3001.
31.
Yes, my lord.
31/2024.
Yes, my lord.
Where is the type portion?
My lord, type portion page 20. My lord, I am reading.
Yes.
Accused also is absent without any step and issue order.
So
of arrest.
you violated the bail condition, rightly so.
Yes. My lord, that's right.
You violated it.
Yes. My lord, he could not communicate with his engaging counsel. Himself was failed and
There's
connect-
nothing. There's no.
No. My lord, therefore, my lord,
You have no case. Sorry.
Yes, my lord. Therefore, under section 482, my lord, I have filed. Honorable
First, let
court
him
will
appear
consider.
before the trial court as per the order of the my lord.
And my lord, kindly
There is
examine
nothing here.
what was the report of the jailer, my lord.
That is a different matter. You've
Because
been
no
granted
facility.
bail and you have violated the terms of the bail. If you violate the conditions of the bail, then you are bound to suffer the consequences, right, Mr. Counsel?
Yes, that's right.
Then,
But only for
so,
extraordinary, my lord.
no, we are
condition,
sorry.
my lord. Since a
Which is that order by which you got bail? Which page is that?
That is, my lord, the page 22, my lord. Clearly stated, my lord, on what condition that patient is suffering, my lord. Page 22.
All right. Your N. Uddin.
Yes, ma'am.
Heard Mr. N. Uddin, learned counsel for the petitioner, stop. Also heard Mr. P. Borthakur, learned counsel for learned APP for state of Assam. Stop. The facts of the case is that the petitioner who was arrested in connection with PS case number 72 of 2023, registered under section 21C/29 of NDPS Act dated 27/8/2023, right?
Yes.
Was arrested in connection with so-and-so likhila na. Stop. Thereafter the trial has commenced, right?
No, my lord.
Trial
Custody
has
is not yet submitted.
Was arrested. What did you write first? One more. What are piece of the facts? Okay. Then Komadya was subsequently granted bail.
Interim bail, my lord.
Granted interim bail by the court of.
My lord,
It's not visible here. By the court of.
by the court of, my lord, additional
Session judge.
FTC
By the
number
court of additional session judge -2 within bracket FTC Tinsukia by order dated 11/12/2023 with the conditions that with the condition that he shall appear before the court physically on all dates.
Yes.
Stop. So, next paragraph. Though the petitioner thereafter was appearing before the court of the additional session judge to FTC Tinsukia, subsequently on 31/2024, the accused was the petitioner was absent without any step.
Yes, ma'am.
Stop. Accordingly, warrant of arrest was issued against the petitioner by the Court of Additional Session Judge FTC number 2 NDPS Tinsukia. Stop. Aggrieved by the aforesaid order dated 31/2024, the present revision petition, criminal revision petition under section 482 has been filed before this honorable court. Stop. Mr. N. Next para. Mr. N. Udin submits that the petitioner has developed HIV, has been tested positive for HIV during pendency of the judicial custody, and keeping that in mind, this court had granted interim bail. Stop. Mr. Borthakur, learned APP, on the other hand, strongly opposes the prayer of setting aside and quashing the order dated 31/2024 as the petitioner has violated the terms and condition of the interim bail granted. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the Court of Additional Session Judge 2 FTC Tinsukia within bracket NDPS, while granting interim bail to the petitioner, had clearly indicated that violation of any of the conditions, including that of the appearance of the petitioner before the trial court, before the special judge FTC NDPS shall violation of the amendment the bail interim bail granted shall stand cancelled. Stop. In view of the aforesaid order, considering that the petitioner was absent on 31/2024 before the additional special judge FTC number 2 NDPS Tinsukia without steps, this court warrants no interference of the aforesaid order. Stop. Accordingly, the criminal revision petition stands dismissed. Yes.
Please.
Yes.
This is an application under section 482, read with article 27 for quashing or setting aside the impugn.
Who is
438 application?
Yes.
The FIR is in page lordship applicable. Full statement is that one has treated at.
So we will call, but interim. Right. Heard Mr. A. Stop. This is an Act in 73 for granting number 2 Abdul Kalam in connection with Udorbon PS within bracket GR diary fixing.
My lord, from
of the case, it is provided
one line objection, my lord, 392, my lord.
50,000 with one sure that the petitioner shall cooperate. Condition number 2 that for after you say call him pre-arrest bail. 10, 12, 20.
Taking the case book.
The are as regard
438 application. The respect Hubmill submission is that the issue. Time and again 8,000 and eaten seedlings and quarrel. And then at that point of time,
the accused where in them.
Petition, madam. That is
About 2 o'clock.
I know.
6.
Yes, my lord. My lord. Not name, my lord, but
page
arrived Nongao PS. And so above referred GD has been. My name is my lord Hasibul Islam.
Possession of one Ali Hussain.
Yes, my lord.
Then against the present petitioner, Mr. Parashar.
I will cooperate, my lord.
That's all right.
Protected, my lord.
Girl is not recovered.
Girl is not. They got married. They had love affairs and they got married.
When can we, Mr. Parashar? When can you have it?
Jalukbari, my lord, short, we can fix my lord on 12, my lord.
12 what do you pare, Marchi?
12.
Call for the CD. Stop. List this matter on 12/3/2024.
This matter may be taken up. Published.
Yes.
Yes, I have received the deputy position filed by the SPT.
You want to file something or you want time?
Time, Lord.
Your name?
Miss A. Begum.
Miss MS A. Begum, Learned Counsel for the petitioner submits that a copy of the that she has received the copy of the affidavit in opposition filed by the respondent number.
Yesterday.
Respondent number.
Only on
Respondent number 2 yesterday. Stop. Accordingly, she seeks some time for obtaining instructions in the matter. Stop. Prayer not opposed. List after 2 weeks on a date to be fixed by the registrar.
Lordship.
Yes, Mr. Bora. FIR. Washing. Where is the FIR?
Case diary not received.
Case diary is required in this quashing petition.
My lord, yes, my lord, from Dispur.
Nothing, my lord. We have challenged.
What is the FIR?
FIR at page, my lord, 17. We have challenged the FIR because no case has been made out from the fair reading of the FIR.
Yes, Mr. Parashar.
All request to our senior, my lord. Maybe fix at 2, my lord. Didas will appear, my lord. APP Didas will appear, my lord, at 2, my lord.
At 2?
If not convenience to see.
Let me just have a look at the. It appears to be a very short FIR.
Yes.
Yes, Mr. Bora, just read the FIR.
Yes, Mr. I hereby inform you that Mr. Devojit Deuri, is the my lord petitioner, had got married with me in the year 2008, which concealed that actual fact that he has already been married with another lady. The entire scenario has come into picture after spending 2.5 years while I was conceived. Moreover, despite of self, I have been continued my life with him along with my child last August 2022. But suddenly he stopped providing food and shelter to us. But very surprisingly, last few months the behavior of so-and-so has changed and compelled me to withdraw the name of his father, whereby his written name from all the document certificates and establish significance myself as a single mother. When I did not agree with the same, as agreed upon me, he frequently gave me threatening of my life and my family members.
498A.
498A.
On 21/23, he was called, my lord.
When can you have it? Tomorrow?
From Dispur, my lord.
Yes, you can have it tomorrow then.
Yes, my lord.
We'll have it tomorrow then. You have, tell Mr. Das also.
That's not true also, dear my lord, whether service or not.
Service is complete.
Who is R2?
Mr. Gogoi.
The informant.
Nimson.
The difficulty is, no, someone has already entered appearance on behalf of R2.
Yes, yes.
R2 is complete. Alright, then we have it tomorrow, Mr. Bora. In the meantime, since they are insisting so much to have the case diary, let's list this matter tomorrow, enabling the Office of the Public Prosecutor to place the case diary as called for.
Obliged.
My lord, kindly pass over the day, my lord. My senior is out of it.
20. My lord, it is a matter of 125 matter. The proceedings, they have challenged the order of the landed court below.
Petitioner is not there today, Mr.
Yes, my lord.
Biswas.
My only
You are the informant.
Let that be 1 year for adjournment. But they have to clear the maintenance. Till today, not a single pie has been paid by the husband.
How much?
4,000 for the wife, 2,000 for the child.
4,000 for the
child.
And 2,000 for the wife.
No, 4,000 for the wife.
Which is the order?
Order, my lord, I take your lordship, but it is the order dated 20. That's your idea.
This matter is going on since 23.
Yes.
Yes.
They are not paying a single further.
Yes, Mr. Biswas, where is the order?
Well, the pay is 13. Yes. 14, 10, 22. It is there in actual, my lord.
Yes.
So let them clear the dues, my lord. Let it, they enjoy the long.
Where is that portion? The relevant portion?
My lord, that is in page 20. Keeping social status of both the parties and medical expenses of the sister of the second party, I deem it fit to direct the second party to pay monthly maintenance of 4,000 first party and
We can have this matter on Monday?
Wednesday, my lord.
No, Monday. In otherwise we are allowing.
My lord.
Monday without fail.
They'll pay by Monday, but amount, but they're not paying. How this lady will survive?
But they have challenged this. His senior is not there today.
There is no stay order from the court.
Then you have other remedies open.
No, that's true, but court is saying that the court below matter is
There are
pending
no
in the high
stay
court.
orders. You avail your remedies open to you.
No, that, madam, I can go, but problem
Yes,
is that
what is your name?
P. Buragohai.
Mr. P. Boragohai, Learned Counsel for the petitioner, submits that his senior, Mr.
S.C. Das.
S.
S.C. Das.
S.E. Das.
Yes.
S.E. Das. S.C. Das.
S.S.T.
S.C. Das is indisposed.
Yes.
Is indisposed and accordingly seeks for accommodation for the day. Stop. Prayer is opposed by Mr. S.C. Biswas, Learned Counsel for the respondent. Stop. Be that as it may, list this matter on Monday, 11/3/2024. Stop. It is made clear that no adjournments shall be granted. Okay?
Obliged, sir.
No further adjournment. Yes.
I'm playing now office card.
Jimma.
Yes. This on the report by an order dated called for report of the IOL.
Yes, you have the report.
Regarding ownership of the card.
I'm for the respondent of card.
Report. Who is going to submit the report?
Okay. official note dated 11/8.
I think from the concerned IO.
Yes, my lord, yes, my lord. My lord, report today I have not received. My lord, any short date may be fixed. I will get the report.
Official note dated 11/8/2023 reveals that the report is already.
Report is received by?
Still.
No, but it has to.
Yes.
Yet
Then I will go
report.
through it, my lord, at 2. I will go through it.
Maitri at kiba report dise niki?
Yes.
It file up to time. Oh, wait. No, there is one report here. It says 2 vehicles have been seized and both parties has not yet to be submitted relevant documents.
Yes.
I have annexed the RC of the car.
Anyway, let Mr. Bhattakur, you have a look at it.
Yes, yes.
We'll have it on Monday.
Monday, yes.
Monday both hote na? You say that list this matter on 11/3/2024 to enable Mr. P. Bhattakur Leonard APP to examine the report which was sent directly to the registry from the office of the concerned IO. Yes.
Yes.
Please, Your Lordship.
Yes, Mr. Ganguly.
Yes, Lordship, the petitioner is aggrieved with the rejection of his prayer for Jimma. Actually, what has happened, petitioner is the registered owner of a truck, Lordship, which was involved in a criminal case, Lordship. The driver was arrested, petitioner is the registered owner. He is no way connected. Either in the offence report, it is a excise case, Lordship. The driver who was arrested was enlarged on bail. Some Orunachali IMFL liquor and this truck was seized. Now, the petitioner made a prayer before the learned session regarding the release of his vehicle. Now, the manner in which the entire petition has been dealt with, Lordship will find the impugned order at page 25.
Yes.
May I read, Lordship?
Yes.
Yes. Learned advocate for so-and-so is present. The report called for from the IO by order dated 3/10/2023 is received. The IO has submitted a report wherein it is stated that the investigation of the case is not yet completed and the seized vehicle bearing registration number so-and-so required for further investigation. The IO has also reported that he has sent an email to the Superintendent of Excise Lakhimpur to DTO Kamrup Rural to clarify the details of the seized vehicle, and the DTO Kamrup Rural replied through email and clarifies the details of the seized vehicle with the registered owner, and a copy of the same is enclosed along with the report and hence paid before this court not to consider the Jimma prayer of the petitioner at this stage. Here is the case report, seen the report, heard both sides.
Where is the application of mind?
There is absolutely no application of mind.
That is not any council excise department.
They were appearing, all in all, they had appeared, but this time around, either.
The names are showing.
Will inform of
this item number
22.
22. Yes, Standing Council Excise Department name is shown. The truck that was seized had IMFC.
Yes. IMFL liquor. IMFL liquor.
IMFL liquor. And you are the owner.
I'm the registered owner.
And the driver is already released on bail.
Yes, yes. Released by this honorable court. That is necessary with the either with the investigation or the trial. That is no way necessary either in the trial or in the investigation of the case at all.
Yes.
I will inform the Standing Council excise.
You wait for some time then. Yes, sir. So next to Mata. Mr. Ganguly, just wait for some time. Yes, Mr. Bhuya.
Worship, other side, my lord,
Respondents.
service completed, LCR already received. And my lord, Posley's phone, the advocate name.
What is to be done then? They are not there today.
But
We'll fix it for...
motor shall continue.
Can we admit and fix it for hearing?
And dispute matter. One magistrate saying
You are on interim.
Lordship. One magistrate, learned magistrate, saying that proceeding.
OP. Item number 23, you're right. Heard Mr. K. Bhuya, right? Learned counsel for the petitioner, stop. None appears for the respondent. Number 1 and 2. For the respondent number 1 and 2 when the matter was called. Stop. It appears that the LCR call for by order dated 20/12/2023 has been received. List this matter after 4 weeks on a date to be fixed by the registrar. In the interim order, if any, shall continue to. Yes, Mr. Kotoki. What transfer you want?
No, actually, what happened is there was a memorandum of settlement. Your Lordship may kindly come to the
Where?
flag X.
Mediation.
Mediation report has been given. It was settlement.
Yes. So you want to withdraw on the basis of
No,
the
actually,
settlement?
it may be disposed of. Your Lordship may kindly see. Do we have already partially complied with the order of negotiation? There was amount fixed was 22 lakhs, and we already paid 11 lakhs first installment. That page 3, Roman 4, my lord.
Page
3, Roman 4 of the agreement.
Where is the agreement?
Mark is X, my lord.
It's
like Mark X. Mediation report.
This is mediation report.
Yes,
but
madam.
there is no agreement with that.
Agreement is not exclusive.
No, it is there, but there is no Roman. It is numerical.
Numerical 6.
Numerical
6. And then
page 6.
page 3, my lord.
Yes, number. Okay, paragraph 6. Yes,
Paragraph 6, Roman 4.
Yes.
Paragraph 4.
Yes.
Yes, sir. So was the both parties have settled.
You are the husband?
Yeah, I am the husband. Both the parties have settled the dispute amicably. So the husband agreed to pay rupees 22 lakhs.
You are for the wife?
My lord. So agreed amount was rupees 22 lakhs. While given her consent to give divorce to her husband, he will not contest the divorce. Husband agreed to pay the agreed amount of rupees 22 lakhs in 2 installments. First installment was 11 lakhs.
Have you received?
Yes, it was. Second installment, my lord, check number was given, and it will be paid on the date of order of divorce.
The first installment paid?
Paid, my lord.
Yes.
Then your lordship may kindly come to next page, my lord. On payment of full amount, then the wife will file an appropriate application before the principal judge
For withdrawal. Yes.
Then gave her liberty to take spiritual property which were like, and that was also taken. It was taken on second.
Yes.
It was already off. Now, and then, so now number 10 is important now.
Yes.
Both parties shall file joint petition in FC civil case number so pending in the court for resolution of marriage.
Yes. This is not done.
Proposal of that both petition.
This is not done.
This is not because this case is pending before this. You will also dispose of it of in terms of the settlement between the parties so that we can file divorce application before.
In this, what was challenged?
Actually, what has happened? There are 2 proceedings. One proceeding was...
You wanted to transfer the case pending in the Court of Principal Judge, Family Court, Dhugri, to the Court of Principal Judge number 3, Kamrup at Guwahati. This is what you wanted. So now you don't want to press this because of the settlement, correct?
And they also filed one...
Not necessary.
No, it is also come.
So there are 2 petitions.
Yes, my lord. The next item.
Next.
My lord.
They also wanted to transfer.
Transfer the civil case, my lord. Divorce case pending in the family court to Dhugri.
Same. Okay. First you write in 57. Heard Mr. P. Kotoki, learned counsel for the petitioner. Stop. Also heard Mr.
DJ Haloy.
DJ Haloy, learned counsel for the respondent.
Respondent.
Transfer your lordship.
2 respondents or 1 respondent?
One respondent.
Sole respondent. Stop. This is an application under section 407 of the Code of Criminal Procedure 1973 for transferring of FP criminal case number 123 of 2023 pending in the Court of Principal Judge Family Court, Dhubri, to the Court of Principal Judge number 3 within Kamrup within bracket M at Guwahati. Stop. It is submitted at bar that the parties have.
The passage order passed by your court.
Sorry, it is submitted. It is submitted at the bar that the mediation center has forwarded a report dated 27/2/2024, whereby it appears, whereby it is recorded that the parties have submitted a settlement report between both the parties stating that mediation has been successful. Stop. A copy of the memorandum of settlement under section 89 of the Code of Civil Procedure 1908 is also annexed to the said report. Stop. A perusal of the aforesaid memorandum of settlement makes it abundantly clear that the parties have already settled the dispute between them. Stop. In view of the aforesaid endorsement made by the parties, nothing survives in this criminal revision petition. Stop. Transfer petition. Stop. Accordingly, the criminal transfer petition stands disposed of in terms of the aforesaid endorsement. Alright?
Yes.
Stop. Next also you make the same, but there the parties get changed. Petitioner will be S. Das and respondent will be P. Kotoki, and that first paragraph you see it from that cost title. Only that much will change. The rest will be all same. Okay? So 57, 58 both disposed of.
And the interim order stands. There was a stay order was there.
So that stands vacated. Yes. Interim order passed earlier shall stand vacated in both. Cost to use in item 58. You show it to me the file. CD?
Item number 25, case diary not received.
Await CD, list this matter on
3rd of April.
3/4/2024. to Mata. CD, Mr. Das?
CD LCR has called for skin has come. So time being kindly.
All right. CD?
Yes, Malo. Case diary received, Malo.
Yes. This is 394-224-332.
Item number 27, Malo. 384.
Yes.
Of 24, Malo.
Where is the FIR?
FIR is 13, my lord.
Yes. Read.
My lord. I'm reading, my lord.
Yes.
Would you respect and humble submission, I have the honor to report that in connection with above reference case on Panjul Das son of Songso, Diwali Port number Songso, Romia district, Kamrup, had been extended on 24/12/23. During the interrogation, he disclosed that one Asim Odhikari arrested Alpha Linkman in connection with the Zalubur case customer Songso under section Songso, every section Songso and Songso Arms Act, deputed him to hoist the flag of Alpha. This is the allegation, my lord. At Bayata and Komolpur area.
Initially, he was arrested in a, my lord, different case, my lord, that is under section, my lord, 121, 121A and reduced, my lord, UAP Act.
121?
121A, ARPC, reduced, my lord, 10 and 12 of the UAP Act. And, my lord, while, my lord, in that case, he was...
Maitri, a UAP Act.
Well, but in this case, my lord, that is, my lord, in this case, my lord, while he was already arrested in that case, my lord, in this case he was shown arrested, my lord, on 18/1/24. What happened, my lord, my lord, in this case, my lord, while my lord, by taking him, police is trying to search some other accused related to the other case, my lord, in which he was already arrested. At that point of time, my lord, he is trying to, my lord, escape from the police custody by way of snatching the rifle of the police personnel. So in this case, that is the allegation against the accused.
Here, the allegation is that he was trying to escape.
Escape, my lord, while in police custody and by snatching the, my lord.
Where that is there in the CD?
Yes, my lord, that is in the FIR also.
Which part in the FIR?
Here, FIR, under section FIR registered under section 353, 394, 332, my lord.
Page 13?
Yes, page 13 is the present FIR.
So that hosting of the alpha flag is related to another case.
That is, my lord, in a different case.
That is a different case.
In judicial custody. That is in respect of Kamalpur PS case number 198/23.
Asim Adhikari is a different person.
Different person.
What is your name?
Pranjal Das.
Where, yes.
Pranjal Das.
When the police party reached Salmara under so-and-so, Pranjal Das asked the driver to stop the vehicle. That is...
yes, Pranjal Das asked the driver to stop the vehicle for attending nature's call, and accordingly we stopped the vehicle near the roadside. H.G. Rizu Ali brought him to the roadside for attending the nature's call. The accused Pranjal Das suddenly attacked.
So, now why was Pranjal Das first taken by them? Where is that part? As per statement of accused Pranjal Das.
In search of some other accused, my lord, related to the earlier.
All right then.
This, my lord.
Sorry?
My lord.
What? You were saying something?
My lord, he is remaining jail 38 days in this case, my lord. In other case, my lord.
Take your seat.
My lord.
Heard Mr. K. Udin?
A.K. Azad.
A.K. Azad, learned counsel for the petition. Top. Also heard Mr. P. Borthakur, learned APP Assam. Top. This is an application under section 439 of the Code of Criminal Procedure for granting regular bail to the accused petitioner, I. Sri Pranjal Das, who has been shown arrested on 18/1/2024 in connection with Baihata Chariali PS case number 397 of 2023 within bracket DR 1367/23 registered under section 353, 394, 224, 332 of IPC. Stop. The case of the prosecution is that the accused petitioner, that the petitioner was taken into custody.
Shown arrest in this case, was arrested in this case on 18/1/24.
No, not that. Was no, they had taken him into custody in connection to find out about some other accused. Correct? This is what you said.
Earlier, my lord, he was already in custody in my lord, in one other case from 24/12/23. He was already in custody. In this case, my lord, after committing this offence, my lord, he was shown arrested.
No, I am not on that. Yes. You see, in this case, the allegation is that while he was taken, he tried to escape. That is the allegation in this case, right? But initially, why was he taken into custody?
Initially, my lord, regarding my lord, some Ulfa activities, he was arrested. My lord.
That is what I am asking. The petitioner was initially taken into custody in order to find out, in order to interrogate him in connection with some alpha activities. Stop. Thereafter, while he was being moved to Sipajohar to apprehend another accused in the government vehicle AS 39338, the petitioner after making an excuse to attend nature's call, comma, managed to escape from the police custody by attacking the police officer and by attacking one police officer and by snatching his rifle. Stop. Correct? Mr. Bhattakur?
Yes, sir.
Stop. Accordingly, a case was registered. Stop. Mr. A.K. Azad, Learned Counsel for the petitioner, submits that the petitioner is totally innocent and has been wrongly implicated in the matter. Stop. Mr. Bhattakur, P. Bhattakur, Learned APP, on the other hand, strongly opposes the prayer for the bail. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. There is no adverse material otherwise against him, right, Mr. Bhattakur?
Adverse material is there, my lord, because at that point of time, while he is in police custody,
He was trying to escape.
snatch the police
That is
rifle
the only
and-
thing.
Yes,
But his interrogation otherwise is done.
well, interrogation already he is in police custody.
So it's all
While-
done.
Yes.
Considering the totality and the circumstances of the case, and also keeping in mind that the purpose of taking the petitioner into custody initially was
in respect of
Kamalpur
PS case number,
was in respect of another case concerning the activities of Alpha. Stop.
Yes.
This court is of the considered view that further detention is not necessary. Stop. Next para. Accordingly, it is provided that the accused petitioner named above shall be released on bail in connection with the above noted case with a bail bond of rupees 30,000?
Yes.
30,000 only, with one surety of the like amount, with the satisfaction of the learned SDJM Rongya, subject to the following conditions. Number 1, investigating officer, and number 2, that inducement. Number 3, refrain. Return the case diary. And the bail application stands disposed of.
There is an interim.
In item 25. In item 25, you write, if interim, if any, shall continue. Yes.
Call for the CD.
CD available.
It is available, Mr. Das?
CD is available.
Yes.
Allegation is my father-in-law has lodged an affair against the son-in-law, but he has killed his daughter.
Yes, Mr. Bora.
By hanging in a tree.
Hanging in a tree?
While the petitioner was asleep, right in the morning at around 4 a.m. That is the allegation.
Father-in-law.
Father-in-law. Because earlier that...
There are two accused who you are appearing for?
Only one. There are only one petitioner.
What is the name? Dhiraj
Dhiraj
Patgiri.
He was only arrested, man. No other person. So there, initially the marriage took place by eloping her. That is the grievances the father-in-law still have.
Yes, Mr. Das.
Yes, Lordship. The accused petitioner, Lordship, is the husband of the deceased. And they have been married for 4 years, Lordship, before this incident took place, Lordship. And however, the witnesses are there who have stated that demand of dowry is there. And one of the witnesses know this, Lordship. No. And
There are evidence of demand of dowry.
Lordship. And moreover, normal fightings are there, Lordship, quarrel with each other, Lordship. And however, the
fire is registered under what? 302?
302. But Lordship, as per this witnesses, Lordship, and moreover, 30, or Lordship, the PM report is not available with in the CD, Lordship. Moreover, police and other persons.
When can you have the PM report?
Request has been made on postmortem report, Lordship, 14/1/2024.
Because that would indicate whether 302 is involved or not.
If there is any strangulation, that will come up in the PM report.
So let's wait for the PM report then. That would be appropriate.
Already I am expected for 49 days.
When can you have it? Have it in the next week because he's in jail since last
49 days.
49 days.
However, this is 90 days.
All right.
Lordship.
So that's when can you have it? I say that though the case diary, upon perusal of the case diary, it appears that the PM report is not part of it. In order to ascertain the cause of the death of the deceased, it would be essential. It would be necessary to have a look at that PM report. Accordingly, let the PM report along with up-to-date case diary be submitted, be produced before this court on 15/3/2024. List accordingly. 28.
Can the matter be taken after some time, my lord, Mr. S. appearing, but he is already stuck up in.
CD is there?
CD is there.
After
all of it.
Deeply, okay.
CD there?
Elsewhere is there, I have done.
But petitioner is not there. 59.
Yes, this is yesterday, I think, today it has been fixed, my lord.
And we wait for some time? Yes, 60.
60 CD not available, my lord.
Not available. Mr. Ahmed?
The petition are in custody.
When can you have it? Next week, Mr. Parashar?
Procedural, Lordship.
Okay, so you can have it on tomorrow?
Monday, my lord.
Monday?
Monday, my lord.
Await CD list again on 11/3/2024. Yes. Yes, excise, Mr. Gogoi.
I'll seek some time by Monday, my lord. I have to call
What
for the offense
time the
report.
trucks? Why do you need
No,
the
my lord,
trucks?
no. There is a proposition laid down, my lord. The Zimma can be granted only in case of charge sheet has been filed, only when charge sheet is filed, my lords. So if that charge sheet is filed, then he has to approach the lower court. If it is not filed by Monday, my lord, let me bring the instructions, then he can take away the truck. I'll have to bring the offense report.
You see, Mr. Gogoi, come to the impugn order.
My lords.
Where is the application of mind here?
That's an issue, my lord.
And as far as this court
Cryptic,
is
my lord.
concerned,
The order, I have to admit, is very cryptic. Nothing is there.
absolutely no application of mind at all.
Yes, my lord.
How can an order be passed like this?
Yes, my lord. I understand. But rightly or wrong, my lord, there's a proposition, my lord, that charge sheet has to be submitted only then. There's a proposition, my lord.
Proposition.
In fact, it has been settled by this court also, my lord.
There is a proposition or there is a precedent?
It's a precedent for now. So, my lord, see.
Language of section 451 is.
No, my lord. No. That I can differentiate, my lord. What is inquiry and what is trial? Inquiry doesn't mean by the IO, my lord. Inquiry is to be the court. That is charge sheet, my lords.
But Mr. Gogoi, 451 doesn't talk about charge sheet.
My lord, the inquiry word, my lord, it has been Nevada Properties case, my lord, it has been enunciated.
Is there any other decision of the apex court?
That I have to
says
bring,
that
my lord.
unless
Yes,
there
yes,
is a
yes.
charge
I
sheet,
can bring on Monday, my lord. There's a
because
100% case.
otherwise this court is not.
Sundar Bhai, my lord.
Yes.
No, man, it does.
Sorry,
it
it
does-
has been enumerated by the apex court in what circumstances vehicles. The apex court is of the opinion that the vehicle should not be kept in the vehicle for
That
long.
is- that is
and
all
not
right.
less than 6 months.
That is
the
okay,
period.
but as regards the point here, it says that unless the charge sheet is filed, the petition is premature. This is what Mr. Gogoi is also trying to say on the basis of this. All right. Now, plain reading of 451.
That language itself, inquiry word,
I
it doesn't
do not.
inquiry. Doesn't,
I have my own reservations.
So, while I can clarify on Monday also, I can bring the offense report also. That inquiry word, my lord, inquiry
Inquiry means every inquiry other than a trial conducted under this court by magistrate or court.
No. Inquiry means, my lord, it is held in, my lord's, the Hardeep Singh's case, my lord. It is inquiry by Justice Gogoi. The inquiry doesn't mean here in, my lord, the inquiry by the IO, my lord. It's an inquiry after charge sheet the court embarks upon. That is the language, my lord.
The safeguards are already there. The magistrate is empowered even to record evidence while granting GIM of a vehicle.
And even, my lord,
the investigating officer can make an inventory list whereby lordship he can.
Now, you point out from the order dated 7/10/23 where all these prerequisites have been taken care of. Where have the court,
that I have to admit, my
subordinate
lords.
court
That is why I was harping about.
I think they have not applied the
and my
mind
lords-
as regards the natural. Nothing has been done.
These are, my lord, these vehicles, my lord, this is a.
The learned trial
my lord, that apart, my lord, this Sundar Bhai Ambala has another citation, my lord. On the same book, on the next page, my lord, it starts, my lord.
That's what?
It says, my lord, if a vehicle is produced doesn't mean, my lord, physical production. If a learned magistrate or the IO says it's been seized, it is enough, my lord.
The thing which the trial court has to keep in mind is whether the vehicle is at all required for the purpose of.
One second, Mr. Ganguly. Yes, 451 doesn't say anything more than this.
Exactly, my lord. That is the precedent, my lord. In few,
What is the other case you are referring to? Show me. Sundarban.
Yes.
That
lordship.
Mr. Gogoi, Mr. Ganguly has a right to
Yes,
say
yes,
his
no, I'm not-
arguments.
I'm just.
I don't know
laughing.
why you are laughing.
No, my lord, I am laughing at
Nothing
myself.
to
My lord. I
laugh
didn't
about.
bring the judgment, my lord.
Yes, Mr. Ganguly.
SCC 283. The only para 17 I may read, lordship. In our
You
view.
don't have a copy? Just pass it. Paragraph 7.
Paragraph 7, 8, 14 and 17.
Paragraph 17 or 7?
14 and 17. How the old ornaments, how they are to be dealt with. How.
One second. Both side is getting very anxious.
No, I am not
This
anxious. I am
court
just.
cannot.
I am handicapped because I don't have here the citation. I only have my mobile.
Yes, How long is this vehicle in the police station?
Yes, it is. Date of seizure. Three 2023.
3/8/23.
Yes.
We can do like this, Mr. Gogoi and Mr. Ganguly. We can say that since the order dated 7/10/2023 does not indicate any application of mine whatsoever,
That can be done.
let the petitioner approach and let that application be disposed of in accordance with law by keeping the parameters of section 451.
My lord.
That can be done. Because you see, it makes no sense of keeping this truck for so long. Since August 2023, it is kept at the police station, right? For what purpose? I don't know if there. So that application of mine somewhere has to be made.
Let them
If it is required, you make out your case. You also
The only difficulty is that the petitioner purchased the vehicle through bank finance. And for the last 4-5 months, he is unable to even pay his.
So you make this argument before that. I am not
precisely
deciding anything here.
The difficulty with the petitioner is.
Since there has been no adjudication to your prayer,
Yes,
correct? And simply it has been rejected. So
The learned trial court has
we
received
remanded
a
back.
report without mentioning the name of the registered owner even.
Absolutely. That is why I am saying. So we shall remand it back for a fresh consideration.
That can be done, my lord.
Right? To item number
22.
In item number 22, okay. Heard Mr. A. Ganguly, learned counsel for the petitioner. Top. Also heard Mr. D. Gogoi.
Yes, ma'am.
D. Gogoi, learned standing
counsel,
counsel, excise department. Top. This is an application under section 401 read with section 397 of the RPC 1973 for setting aside the impugned order dated 7/10/2023 passed by the learned subdivisional judicial magistrate within bracket S, Lakhimpur, North Lakhimpur, in CR within bracket excise, case number 14/2023 under section 53 within bracket 1 within bracket 8 of the Assam Excise Amendment Act 2018, where the learned court below rejected the prayer of the petitioner for Jima of Tata truck bearing registration number AS25FC3278. Stop. The facts of the case is that at about 7:55 p.m., the jurisdictional inspector of excise, along with patrol party, intercepted a truck bearing registration number AS25FC3278 at Pathalli Pahar near Tollgate on National Highway 15 and accordingly recovered IMFL and beer in presence of witnesses. Correct?
Right.
Stop. Accordingly, a case was registered. Stop. In connection with the aforesaid case, the said vehicle was seized. Stop. The petitioner is the owner, registered owner of the said vehicle. Stop. The petitioner filed a Jima petition before the Court of Learned SDGM within bracket S, Lakhimpur, North Lakhimpur, being petition number 2988 of 2023 for granting the custody of the said Tata truck bearing registration number AS25FC3278. Stop. However, the learned court, however, the learned court below, don't say learned court below, however, the SDGM, Court of SDGM within bracket S, by order dated 3/10/2023, no, not that, by order dated 7/10/2023, rejected the JIMA petition, that JIMA petition. Stop. Mr. A. Ganguly, next para, Mr. A. Ganguly, learned counsel for the petitioner, submits that the this is committed court or trial court?
It's a trial court.
The trial court has passed the rejection order in a most mechanical way, mechanical manner, without any application of mine whatsoever. Stop. He further submits that the driver of the said vehicle, who was apprehended at the spot, has already been released on bail by this court. By order dated? Just give me the order dated. So and so, huh? And
page
then
21 to 22.
Page 21, Annexure 5.
Order dated
1923.
1923
in BA number 3023.
In BA number
3023/23.
He further submits that the subject truck has been in custody of the police since 3/8/2023. Next para. Mr. D. Gogoi, Learned Counsel, Learned Standing Counsel, Excise Department, strongly opposes the prayer made in the revision petition. No, not
I'm
strongly.
not opposing, my lord. I'm not opposing. Let the lower court take a view.
Don't say strongly. Says you say he submits that.
That I'll admit, my lord. This order was cryptic. Non-application of mine is apparent on the record, my lord. Nothing on merits.
Mr. D. Gogoi, Learned Standing Counsel, Excise Department, fairly submits before this court that a bare perusal of the impugned order dated so and so indicates that the prerequisites of section 451 of the CRPC hasn't been met with. Stop. Then you say section 451 of the CRPC is reproduced hereunder for ready reference, quote unquote. This code section. On top you say I've heard the submission made at the bar and I've perused the materials available on record. Then you quote this, huh? It is apparent on the reading of the impugned order dated 7/10/2023 that the Court of SDJM S. Lakhimpur has not has passed the said has rejected the prayer of JIMA of the petitioner without any application of mine whatsoever. Stop. That being so, the aforesaid order dated 7/10/2023 passed by so and so is set aside and quashed. Stop. In view of the above order, the matter is remanded back to the Court of SDJM Lakhimpur, not Lakhimpur, to rehear the JIMA petition number. The reference is already given to you. The JIMA petition number so and so, fresh, by taking in accordance with law.
In the light of that judgment,
that will be on merits.
With the aforesaid observation direction, this petition stands disposed.
Obliged.
Ito kiman number goal? Ito tat bharai diyo. Bole beya ho gaya. Na? Enake thako. I shall just come back in 5 minutes.
Obliged.
Ready. 59 ready.
Since long time regarding some dispute over landed property and some other issues.
Yes, Mr. Parashar?
Malad, yes, but here earlier incident we don't know, but as per the FIR, Malad, at that point of time they are Malad, attacked by sharp weapon and husband and son with head injury and chest injury by sharp weapon and critical condition. That is the, and they also lost FIR.
Any cross FIR?
Yes, but that is subsequent. This is on Malad on 22nd of August.
Have any injury on the other side?
Yes, Lordship. I have annexed the medical report.
Next day.
You have also sustained injuries?
Yes, Lordship. Medical report.
This case, Malad.
Immediately, Lord, quarrel was there. Lord. I pray that Lordship, even Lordship, female petitioners are also there, Lordship. Let them record their statement, Lordship.
How many accused?
6, 7, Lordship.
Seven.
All are family members, Lordship. Husband, wife, son, same family, Lord.
Only thing, Mr. Parashar, keeping in mind that there are some land disputes among the family, and it seems that they had gone.
They had.
So it's not pre-planned, or you see, that angle is not there.
But maybe provocative, but head injury.
At the end of the day.
Regarding ladies, serial number 2.
Mr. Parashar, we are not distinguishing them on the basis of gender. It is admittedly what appears is that there has been a land dispute between the two fraction of.
Attacked by sharp weapon and head and chest injury.
But they did not carry the weapon, and it was them who had come there, and on that spot, whatever has happened has happened. So it doesn't seem that it was a planned. Where is your FIR?
Page number 23, Lord.
And where are the medical reports?
Annex 3, Lordship.
Page Annex 2 is your FIR, correct?
Yes, Lordship.
And
even Lordship narrating the same incident, Lordship, it is a dispute, Lordship, as because our board entered into their paddy field.
Yes.
And Lordship, seedlings being eaten by the goats, Lordship, that is the primary.
Okay, and then where are your medical reports?
Lordship, page number 27.
What injuries have you people suffered?
Soft
tissue injury.
Huh?
They got soft tissue injury, and as per the FIR, they are a critical injury.
As per the FIR, Lordship, late case diary we call for, Lordship. Perhaps, Lordship, a case of 323 will be there, Lord.
Case diary is not here.
Motion, Lordship. I am praying for interim only.
This is
motion, Lordship.
Because of that, AB and motion, Malad, because of that, Malad.
All right. Let the case diary be called for short date.
Malad, yes.
At least, Lordship, for the petition 25 and 6, who are the female, Lordship, and
give me a short date.
Thuburi, Malad, on 13. 13, Malad.
13. 13 is Wednesday.
Yes.
13/3/2024.
Highly obliged.
14 হলো এটা মানে মোশন কি মান 26 is bail hearing.
The bail hearing. He is in custody, Miller. Today, Miller, 132 days.
And
offense, Miller, kindly say Annexer 1, Miller, that is Azhar, page 9.
LCR you have received?
LCR is
with case diary?
Isken Gobi Miller has come.
Yes. FIR is at page?
13, Miller. And considered Gobi Miller, page 9. Page 9, Miller, they considered Gobi Miller. Their allegation was made against Miller 8 persons. The main person is Miller, the accused number 1, Jamal Batta. And my name Miller stands in serial number 8, last name. of that.
Mofizil Ali.
Officer Ali, my lord.
What is the allegation against you?
Illegally, my English Milord, allegation is there. I assist the Milord, accused number 1 to kidnap someone. That is the allegation.
Accused number 1 against is the rape.
Well, there is, yes, here's the some other allegation. But against me, Milord, there is no such.
1, 2, and 4 kept her confined.
Yes.
Then accused number 1. Yes. Anything against Mr. Das, against Mofizul Ali?
Lordship, it is there only that he helped my lord, the main accused.
Where?
To kidnap, Lordship.
In the FIR, where?
In the 164 statement.
In FIR, he is not named.
FIR not laid.
And in 161, what has come?
164, Lordship.
164?
He held this person, the petitioner.
164 of the victim?
Lordship.
Yes.
Helped the main accused, Jamal Bacha, to kidnap this person.
Petitioner helped?
Abduct.
Accused 1?
Lordship.
To abduct?
Lordship.
What role did he play?
He called this person, Lordship, on the guise of that he has something that her mother have given him.
The petitioner called whom? Called the
victim, Lordship.
Called the victim. And
Moreover,
said?
said that she first refused, Lordship, but since he stated that her mother has given her something, so he need to come. Then when he come, Lordship, she come, then board her on a vehicle, Lordship. And this all persons are there, Lordship.
Initially in the FIR, his name was not there.
Lordship. FIR is there, Lordship, 8. Accused number 8.
No, but in the narration of events,
yes,
there is nothing about petitioner mentioned.
Lordship, this was at the middle translated copy.
Yes.
Accused number 1, 2, 3, 4, 5, and 8 kidnapped me forcefully, Lordship. 8 is also there.
It is there.
Lordship. The page 10, Lordship.
Yes. I stand corrected. It is, in fact, she is also mentioned in the FIR. Accused number 8, who is the friend of the 1, made a phone call and took my information. And 8 kidnapped me. Only thing thereafter,
Moreover, Lordship, it is under stage is Lordship appearance. Charge has not been framed yet.
Before
Moreover,
the
there are
trial court.
Lordship.
And the trial court.
Moreover, there are 7 witnesses are there, Lordship. Victim statement has not been yet, Lordship.
Not recorded.
Not recorded. Moreover,
how many
informant
witnesses?
Statement is also not. 7.
7.
Charge has not been framed yet, Lordship.
That means in trial way it will be delayed. And moreover, my lord,
it is not delayed.
Today, my lord, I am in 132 days in custody.
Trial is not delayed. Charge sheet submitted 27/11/2023, Lordship.
Some other person.
And next date is was 20/2/2024.
So, my lord,
it need to be up to date.
You see, investigation otherwise is over. Charge sheet has been filed. Correct. Now the question is whether you need the detention is justified or not justified. Undoubtedly, the trial has started, and there are witnesses, victims not recorded. So your apprehension at this stage is that if he is enlarged, the victim may get. This is your apprehension.
Threatening part may be there, Lordship.
When is the next date?
22/24. It has already over, but it is not.
Trial court has not framed charge.
No.
So that will take some time.
But apprehension is there, Lordship.
Now, what is the relation? Are they related? Is he in a position to threaten her?
There is other Milord.
Because 34 is there, Lordship.
No, I'm not. What is? Who is the petitioner? Who is the petitioner?
I am the
informant.
I am the informant.
Victim. Yes.
8. I have no objection.
You don't have any objection.
It is misunderstanding, my lord.
He doesn't have any objection. Then. In item 20. Yeah. Heard Mr. A. Rosid learned counsel for the petitioner, stop. Also heard Mr. P. Borthakur, learned APP for respondent number, for state respondent. Stop. Sorry, KK Das. Learned APP for state respondent. Stop. And Mr. A. Mubarak, learned counsel for respondent number 2, stroke victim. This is an application under section 439 of Code of Criminal Procedure 1973 for grant of bail to the petitioner, i.e. Mofizul Ali Ellis Moto, who was arrested on 26/10/2023 in connection with Dogi Hopa PS case number 270/2023, registered under sections 365, 376, 506, 34 IPC. The case of the prosecution is that the respondent number 2 lodged an FIR dated on 24/10/2023 alleging inter alia that about 3 months ago the FIR mentioned accused number 1 committed rape upon the informant. Stop. In the aforesaid FIR, it was further alleged that the present petitioner, by making called up the informant and asked her to come near the pharmacy, and after she came, the present petitioner along with other co-accused forcefully kidnapped her with her 1.5 years old child and took her to Bilasipara, where she was kept confined. Stop. It is the stop. Mr. A. Roshid, learned counsel for the petitioner, submits that the petitioner has been languishing in jail for the last 132 days. 132 days. Stop. He further submits that there is no allegation against the petitioner as regards committing or helping the FIR mentioned accused number 1 committing rape upon the informant. Stop. Then change para. Mr. KK Das, learned APP Assam, strongly on the other hand strongly opposes the prayer for bail. Stop. He submits that from the statement recorded, he submits that the victim in her statement recorded under section 164 CRPC has clearly implicated the present accused to the effect that it was to the effect that the present accused helped the co-accused to kidnap her forcefully. Stop. He further submits that trial has investigation has been completed and charge sheet has been submitted. Stop. He further submits that charge is yet to be framed in the matter. Stop. That's all. I have heard the submissions made at the bar and have perused the materials available on record. Stop. And on you just mentioned another thing there that Mr. KK Das in his submission, don't say his name, he further submits that if the present petitioner is enlarged on bail, there is a likelihood that he may influence the victim as her statement is yet to be deposed in the court. Stop. Then you say, Mr. Your name?
A. Mubarak.
Mr. A. Mubarak, Learned Counsel, appearing on behalf of the respondent number 2 stroke informant stroke victim, submits that there is no likelihood of he submits that in the event the petitioner is enlarged on bail, there is no likelihood of him threatening the informant victim. Stop. He further submits he has no instruction to oppose the prayer for bail. Stop. Then you say, I've heard the submissions made at the bar and have perused the materials available on record. Stop. After that, you say that considering the totality of the matter and the fact that the trial is yet to begin and that there are how many witnesses?
7.
And there are about 7 witnesses, further detention of the petitioner is not justified. Stop. Accordingly, it is provided that the accused petitioner named above shall be released on bail in connection with the above noted case with a bail bond of rupees 30,000 with one surety of the like amount to the satisfaction of the
Judicial Magistrate Miller, first class.
Judicial Magistrate. Why this information is not kept handy?
I Miller. Page 14 Miller is everything. Judicial Magistrate First Class Miller, North Salmara, Obhayapuri.
Judicial Magistrate First Class, North Salmara, Obhayapuri. Subject to the following condition. Then you say appear before the trial court on all dates fixed from time to time. Okay? That number 1. Number 2, directly inducement 1. And trial court additional. Then return up the case diary. And this application stands.
Awesome.
The LCR was called for is received, madam.
Yes, sir, yes. We have gone through.
59.
No.
And the 380 and 302, it is a suscited case. The court below has rejected prayer several times. And madam, what happened? This petitioner, his motorcycle was used by the abandoned.
Where is the FIR?
FIR receipt signed at page, vernacular page 13, madam.
13.
13, madam. Allegation is the son of the petitioner saw the 2 persons.
13. Yes.
Son of the petitioner, my lord.
Yes.
He saw 2 men stealing a goat from his brother's, informant's brother's house.
Sorry, I didn't get you.
Stealing a goat, my lord.
Goat,
my lord. Subsequently, my lord, the son of the petitioner says them with my lord, in a scooty, taking advantage of my lord darkness, they stab him. And stabbed my lord.
The incident is over stealing of goat. One person has lost his life. Very unfortunate.
And doctor declared him dead. My lord, now let's come to page 15. This is the forwarding report.
Yes, I am at page 15.
Yes, my lord. The grounds of arrest, my lord.
Yes.
In case of me, my lord, ground 5 is, my lord, 11.
Yes.
The motorcycle was found and seized from the scene. Scene is owned by Amina Khatun, who is the wife of the arrested.
What kind of stab injury? By what weapon?
By sharp weapon, the dagger.
It was a dagger. But this person, this petitioner before Losif Asif Ali, he was not present there. His motorcycle, how motorcycle, my lord, came to their hand.
Is it, Mr. Parasar?
Actually, yes.
He was not present. Only his motorcycle was used.
Not present. But my lord, one thing is that, my lord, there are 34 numbers of witness in the search sheet.
till now.
You are Amina Khatun.
No. I am Asif Ali, wife of Amina Khatun, my lord. Wife of Amina Khatun, my lord. I took a husband of the Amina Khatun, my lord. I took a loan from the accused, my lord, this Safiq Ali, my lord. And against that, my lord, he took my motorcycle as a mortgage. Subsequently, he used the motorcycle.
All right. Yes, Mr. Parashar?
Yes, my lord, as per the charge sheet, there is something is that my lord may come to page 28. My lord, charge sheet 34 witness out of 34, 7 examined. And 7 relevant is PW 6 and 4. But they have said that
6 and 4.
6 and 4. I have gone through. But this person is not there. 2 persons were there, my lord. And in the charge sheet, my lord, page 28.
Lordship, start from page 27, last paragraph.
Let the public prosecutor address the court. Yes, Parashar?
Yes, yes. Last paragraph of 27, my lord, yes. 1, 2, 3, 4, 5, 6 line. On reaching census output after the...
Page 27?
27. That is my lord, last
On
line.
reaching, yes, yes. Please read.
My lord, from the... My lord,
I reached. On reaching? Yes.
On reaching census output after interrogation of the complainant, Ajul Rahman and so discovered that the bike doesn't belong to Ajul and who went to the Opian Lodge and missing complaint. Rather, it was found to be belonging to the Safiq Ali.
This is the petitioner?
No. I'm mortgaged.
Then IO also Safiq Ali along with Malak apprehended Aizul Haq. During interrogation, it was said that the discovered Safiq Ali doesn't have any bike. Safiq Ali had kept the bike on mortgage from Asif Ali.
I am Asif Ali, man.
So
admittedly,
yes,
he was not present.
And
his bike was mortgaged to Safiq Ali.
Yes, and
he used it.
They immediately after the incident, they went to the police station, lodged missing complaint of the bike.
Who? Safiq Ali?
No.
Safiq Ali, madam.
Who
not
lodged
Safiq
that
Ali, but Aizul Ali.
Aizul and Safiq?
Aizul and Safiq.
They did done the incident, my lord. That is their, my lord.
But this is Asif Ali.
Asif. But very unfortunate is that, my lord.
It is unfortunate.
Is,
but then that cannot be a ground for curtailing the liberty of this petitioner who was not even present, merely because his motorcycle was used. Yes. In item 59 likhi.
29.7.
Heard Mr. J.C. Gogoi.
J.C. Gogoi, madam.
Learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned APP, Assam. Top. This is an application under section 439 of CRPC 1973, praying for granting bail to the petitioner, i.e. Asif Ali, alias Asif Ali, who was arrested on 29/7/2023 in connection with Sessions case number 230 within bracket NL stroke 2023 arising out of North Lakhimpur PS case number 285 stroke 2023 registered under section 380, 302, 34 IPC. Top. The case of the prosecution is that on 28/7/2023 the informant's son saw two men stealing a goat from the informant's brother's house and taking it on a motorcycle. Stop. He accordingly started shouting and chased the said two men with a scooty. Stop. However, the two men took advantage of darkness and seriously injured his son with a sharp weapon. Though his son was taken to the hospital the hospital, he was declared brought dead. Stop. Accordingly, FIR was registered. Stop. Mr. J.C. Gogoi, learned counsel for the petitioner, submits that the petitioner was not present in the place of occurrence, and it was only his motorbike which he had mortgaged to one Safi Ali, who is the prime accused in the matter, was involved. His motorbike. Stop. He further submits that the present petitioner has been arrested merely on the basis that he is the registered owner of the said motorbike which was used in the incident.
And his wife is the registered owner.
His wife is the registered owner.
Merely on the basis his wife is the registered owner of the said motorbike which was used in the incident. Stop. Mr. KK, next paragraph. Mr. KK Parashar, learned APP, on the other hand, actually you are not opposing.
Yes, I am guessing the facts.
Fairly places the materials away, fairly places before this court, fairly places before this court from the case diary that the petitioner had mortgaged his bike to one Safiku Ali, who by using the motorbike, who was using the motorbike on the date of the incident and on the date of the incident. Stop. In view of the aforesaid submission, this court is of the considered view that further detention of the petitioner is not justified. Stop. Next para. Accordingly, it is provided that the accused petitioner named above shall be released on bail in connection with the above noted case with a bail bond of rupees 15,000 with one surety of the like amount to the satisfaction of the learned
Session Judge,
Lakhimpur, not Lakhimpur, subject to the following conditions. Number one, shall cooperate with, right now it's in the trial stage. Shall appear before the trial court on all dates fixed from time to time.
One line may be added, yes, trial is given only 7 witness exam and more to go. This only for the bail purpose, this observation only for the bail purpose.
And then you say indirect inducement to paragraph condition to logai dibo, return the up-to-date case diary, and then it is needless to clarify that the aforesaid observation is not bearing in any other judicial proceeding whatsoever. No. The bail application stands disposed.
Highly obliged.
Yes.
The petitioner is on interim bail.
Just 1 second. 29 to ki hol, Maitri? 29 to?
Item number 30, search sheet submitted.
Submitted?
Yes.
Already on bail, since 8 months they are on bail.
Okay. Heard Mr. N. Uddin. Learned counsel for the petitioner. Stop. Mr. Borthakur, you are appearing?
Yes.
And also heard Mr. P. Borthakur, learned APP. State. Responded. Then it is submitted by Mr. P. Borthakur, learned additional PP. That charge sheet has been submitted in the case PS number
116
oblique
23
2023 dated
39/23
2023 in connection with
Kolgosia PS case number 8/22.
in connection with
Kolgosia PS case number
PRPS case number
Kolgosia PS case number 1
paisa na
08/23.
In view of the above, the anticipatory bail application stands closed with the direction to the petitioner to appear before the
CGM Borpeta.
CGM Borpeta within 10 days from today
15 days. On ladies.
and seek a regular bail if so advised. Stop. If such bail application is filed, the same shall be disposed of in accordance with law. The interim order dated
Order dated 21/6/2023
21/6/2023 will continue for the next 10 days from the date of this order or till the petitioner's appearance before the learned court below, whichever is earlier. Stop. This disposes of the anticipatory bail application.
Kindly 15 days.
Yes, Mr. Borthakur, 15
15
days?
Yes.
15 kore dibo or 16? 30 na? 30 to hoy gol na?
In this case, case diary not received now.
Disposed of the merchant.
Case diary was called forward.
In 31,
CD not received, madam.
await CD. List this matter again on
4th of April, madam.
4/4/2024. Interim, are you on interim?
Interim.
Interim order, if any, shall continue till the next date.
Plus 7 times.
All right, you're on interim.
Published.
Case diary?
Case diary received, madam.
May I beg your lord?
409, 420, 406.
My lord, and I am on interim bail, my lord.
Yes.
FIR is page 13, my lord.
Page?
13.
Yes.
This is the forwarding. And
Is there a type copy? This is not very legible.
My lord.
Anyway, read. Misappropriation of government funds.
My lord, this is the allegation.
He was the Gaon Panchayat secretary, my lord.
Earlier he was the Gapanjat secretary, now he's
Earlier
retired.
also, my lord, in many cases, my lord, 2-3 cases, he was already arrested. My lord.
Is it?
In this case also, my lord.
So he's a habitual offender.
Yes. Otherwise, in this case, my lord, FIR is lost by the my lord. After completion of the inquiry, my lord, the my lord, chief CEO of the Zilla Parishad, my lord, has lost this FIR against the present.
Now, my lord.
This is anticipatory.
Anticipatory, my lord.
Yes, my lord. And I am on interim, my lord. Earlier on the same allegations, my lord, 2 FIRs were filed against the petition. In one FIR, my lord, that was my lord Rathabadi case number 283/2022. In that case, my lord, the petitioner was arrested. And he was put behind the bars, my lord, for a complete period of 90 days, my lord. And after the completion of the statutory period, my lord, he was released on bail. On the same allegation. Then, my lord, against him, my lord, some other people filed another, my lord, FIR, Rathabadi case number 283/2022. In that case, my lord, he appeared before the learned session judge Karimganj. And he was, my lord, enlarged on anticipatory bail, my lord. Now, thereafter, the
So while he was on bail, he has committed another offence.
Yes, my lord. This is my lord.
Is it?
There are my lord, different.
Same allegations. On the same allegation, 3 FIRs.
Mr. Borthakur, please clarify the query of this court.
Yes.
The present offence that he has been alleged of has been committed while he is in bail in connection with another case.
No, my lord.
Yes, my lord. Obviously, my lord. While now he is already, my lord.
So in the earlier case, when bail was granted,
On 13/12/2022, my lord.
13/12/2022, 2022, bail was granted.
My lord.
And here the allegation is inquiry report is 14/10/2022. That means before. So that will be before then, isn't it?
Yes, he was the secretary, and while he was the secretary, my lord.
But the fact remains that there are habitual, there are complaints of similar nature, right?
Yes. At that, now, my lord, the present my lord petitioner is already retired from service in the year 30/11/21. So all these, my lord, misappropriations were done by him during his period as a Gaon Panchayat secretary, my lord. Under the various schemes, my lord, funds were allocated. Thereafter, my lord, inquiry conducted. And on the, yes, it is true that on the basis of the, my lord, regarding some, my lord, other schemes also, my lord, earlier FIR laws against the present petitioner, he was arrested, my lord. Thereafter, my lord, inquiry was conducted by the chief, my lord, on the by the, my lord, order of the, my lord, CEO Zilla Parishad Karimganj. Thereafter, my lord, after completion of the inquiry, on the basis of the inquiry report, the present FIR is lodged by the, my lord, CEO Zilla Parishad Karimganj.
Now, your lordship, may kindly see, my lord, page 14.
I would like to point out one thing.
He has appeared. His statements have been recorded.
Statement recorded.
What does he say?
He said, my lord, yes, in this case, my lord, here the IO, note of the IO is that, my lord, already, because in other cases regarding other, he was already in judicial custody. So, my lord, only on his, that note is there, but his statement is not available in the case.
Not there.
Not there. But I would like to point out one thing, my lord, yes, my lord, he has...
So then let's call for the up-to-date case diary, because he's already on interim.
He's already on interim.
Let us have his statement then.
My lord.
Thakur?
Yes, then I will get the up-to-date.
To get the up-to-date.
Again, I would like to point out one thing. Yes, my lord, already in earlier regarding the against the schemes against which, my lord, funds were allocated, my lord, against some of the schemes already earlier, first FIR was filed by the 3 members of the, my lord, that, my lord, villager. Thereafter, one another FIR is lodged by the one single individual. Thereafter, when the CEO, he has barely, my lord, I would like to just point out, my lord, my lord, against those schemes against which already, my lord, FIR laws earlier, during this inquiry, my lord, I have gone through the inquiry report. All those schemes are also included in this inquiry report. That is, my lord, I have,
so that means...
That means, my lord, although, my lord, because of earlier those FIRs, those schemes are also included in this inquiry.
But already, FIR is already there in respect of
those cases, already he is in judicial custody. Thereafter, already, after mandatory period, he is already released from...
So then we'll set him free.
That he appeared and cooperated with the otherwise, my lord, sufficient incriminating material against the accused persons, only on the ground because those, my lord, those grounds on the basis of which earlier FIR laws, those all these schemes are included in the present inquiry report.
This is item number?
Otherwise, my lord, there are sufficient...
32, my lord.
Heard Mr. A.R. Talukdar.
My lord.
Learned counsel for the petitioner stop. Also heard Mr. P. Borthakur, learned additional public prosecutor for the state respondent. Stop.
Otherwise, sufficient incriminating material against the...
This is an application under section 438 of the Criminal Procedure Code 1973 for granting of pre-arrest bail to the petitioner, i.e. Rafizul Ali, who is apprehending arrest in connection with Ratabari PS case number 50/2023 corresponding to GR case number 384/2023 registered under section 420, 406, 409, 34 IPC. The facts of the case is that the case diary as called for is placed before the court. Stop. It may be mentioned that by order dated 8/9/2023,
my lord, 8/9/2023.
This court granted the privilege of interim pre-arrest bail to the petitioner subject to condition. Stop. Mr. P. Borthakur, learned APP, submits that the case diary shows that the petitioner appeared before the investigating officer and got his statement recorded under section 161 CRPC.
But there, his statement is
That is not there, but
only
shows.
note of the my lord.
Correct. So that shows,
Yes.
as per interim pre-arrest bail granted earlier. Stop. He further submits that it appears that the inquiry report shows that the same allegations involving the non-implementation of schemes sanctioned by the government of Assam
Yes.
were made as in the earlier two FIR.
Yes. Your Lordship, may I page 19, earlier affair. That is my lord, the one of the scheme is my lord renovation of last pay.
So it's the same thing.
Same thing, and in the inquiry report, my lord, page 14.
Anyway,
same my lord scheme, my lord. That is
next para. This it appears that the petitioner is being subjected to double jeopardy.
Exactly, my lord.
On the same allegation.
Same allegation.
Stop. It further appears that he was arrested and put in jail custody for 90 days in connection with the first FIR, and then in the next case, Rathabari PS case number 283 of 2022, he was granted.
Pre-arrest bail, my lord.
He was granted pre-arrest bail. Stop. As such, this court finds that custodial interrogation of the petitioner may not be required in the interest of the ongoing investigation into the case. Stop. Accordingly, the interim pre-arrest bail granted by order dated
8/9/2023.
8/9/2023 is hereby made absolute with subject to the following conditions. Number 1, corporate investigation. Number 2, indirectly or directly inducement. Those two conditions. All right. And return the case diary. This disposes of the anticipatory bail application. Yes, 33. Case diary, Mr. Bhattakur.
Oh, my lord, in this case, case diary not received.
Not received. Await updated case diary. Stop. Interim order passed earlier. Will continue till then, till the next date, and list on
5th of April,
5/4/2024. Case diary.
No, my lord, case diary not.
Await case diary. List again on 5/4/2024. Interim.
Up to date case diary.
Interim is there. Yes. Interim, if any, shall continue till then. We up to date case diary. List on date to Kidila.
Lordship.
Yes.
Husband
Yes, Mr.
already
Chair.
arrested, my lord, and brother killed another brother, my lord.
Brother killed brother.
Brother killed his brother, my lord. And wife is the wife of the deceased is the informant. I am the wife of the main accused, my lord. Already he is in custody. So,
AB.
yes. Page 9, your lordship.
Page 9. You have the post-mortem report
My lord.
you've received.
That is not disputed, my lord, already because...
Page 9. Yes,
Page
Mr.
9.
Chaudhary.
Yes, page 9. On last 8/12, morning at 8 a.m., there was a quarrel between the accused persons and my mother-in-law, Shahatul Nasa, regarding purchase of ferry to tractor. Regarding that quarrel, again at 7 p.m., accused was called my husband Shahjahan Ali Mullah to his house, gave a blow with sharp weapon in his chest, causing serious injury. After hearing even cry of my husband, I, along with my son Alauddin Mullah, came forward, but the accused person also assaulted us. Local people brought us to so-and-so hospital, suffering to the doctor after examining. They are my husband.
Yes.
Postmortem report, yes, there are 6 numbers of stab injury in stomach and chest.
6 numbers?
6 numbers.
Stab.
Stomach and chest. And main idea is the boy who already injured boy of the disease Alauddin Mullah. He stated that yes, only the main accused who Assanur Mullah logot hadan kaji asil. Takure hani khushi dakham kore.
Main accused means the petitioner.
No.
Mahiran Nessa is who?
Wife of number one.
You are for the wife.
Wife of number one.
Okay. Yes. What does the eyewitness say?
Regarding the main witness,
who is the husband of this petitioner?
Yes.
So there is nothing against Mahiran.
My lord, yes. My lord, both the boy says regarding
Then were you on interim? No.
No.
The lordship was given short date.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. Namtapala, learned counsels for the appellate. Also heard Mr. K.K. Parashar, learned additional public prosecutor for the state respondent. This is an application under section 438 of CRPC 1973 for granting anticipatory bail to the petitioner, i.e. Mahiran Nessa, alias Mohiran Nessa, who is apprehending arrest in connection with Pagun PS case number 73/2023 registered under sections 302, 326, 307, 34 IPC within bracket corresponding to GR number 1471 of 2023. The facts of the case is that on 9/12/2023 an FIR was lodged alleging that there was a quarrel between the FIR mentioned persons and the informant's mother-in-law regarding the threshing of paddy to tractor. And pursuant to the said quarrel, the FIR mentioned accused persons called the informant's husband to their house and gave him a blow with sharp weapon in his chest, causing grievous injuries, to which he ultimately succumbed.
Yes. Taken to the hospital, doctor declared dead.
Accordingly, a case was registered. Mr. H.R.A. Chaudhary, learned senior counsel, submits that the petitioner, who is the wife of
accused number one
of the FIR mentioned accused number 1, is unnecessarily dragged into the matter and has no role whatsoever to play in the alleged offence. Stop. Mr. K. on the next paragraph. Mr. K.K. Parashar submits on the basis of the materials available in the case diary, especially by referring to the statements recorded under 161 of the 2 witnesses who has witnessed the incident. Stop. According to, he further submits that the said 2 witnesses have not stated anything adverse against the present petitioner. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Considering that there are no adverse materials collected against the present petitioner, this court is of the opinion that custodial interrogation of the petitioner may not be required in the interest of the ongoing investigation into the case. Stop. Next para. Considering the facts and circumstances of the case, comma, it is provided that in the event of arrest, the petitioner named above shall be released on pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following condition. Conditions required. Number 1, the petitioner shall appear before the investigating officer within 15 days, failing which on and from the 16th day the pre-arrest bail order shall have no force. Inducement. With the aforesaid observation and direction, this the anticipatory application stands disposed of.
Submit before the Honorable Court on 26 to 2024.
On 20?
26 to 2024, my lord.
Yes.
These petitioners appeared before the IO and got their statement recorded.
Okay.
My lord. They have cooperated with the investigation.
Okay.
Now, my lord, the FIR...
Injury report is there, Mr. Parashar. What is the nature of injury?
Injury, Suleiman Nasa, she got grievous injury in the parietal region, scalp by blunt.
Okay.
Others, other 3% got simple injury by blunt object.
So, mother of the informant,
she got head injury.
Mother head injury.
By grievous.
And others, simple.
Simple injury by simple.
They have already cooperated.
Yes, but her condition is that regarding the vital portion of the body, scalp. But
so they are cooperating. There is no adverse materials against them as regards their antecedents. Correct.
Yes, now regarding
gravity alone will not be a ground for denying them that liberty, right?
Statement recorded.
Okay.
Family dispute is there.
Sorry?
Family dispute is there.
That's right. Heard Mr. B.K. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor for the state of Assam. This is an application under section 438 CRPC praying for pre-arrest bail of the petitioners, namely 1 to 7, no?
1 to 7.
1 to
Of the
7.
same family, my lord.
1 to 7, in paragraph, page number 2. 1 to 7, who are apprehending arrest in connection with Nagaon PS case number 892/2023 registered under sections 447, 326, 307, 34 IPC. Pre-arrest bail. The case diary as called for is placed before the court. It may be mentioned that by order dated 21/2/2024.
Yes, my lord.
21/2/2024, this court granted the privilege of interim pre-arrest bail to the petitioner subject to conditions. Mr. K.K. Parashar, learned APP, submits that the case diary shows that the petitioner appeared before the investigating officer on 26/2/2024 and got their statements recorded under section 161 CRPC as per the interim pre-arrest bail granted earlier. It appears from the inquiry report that except the mother of the informant, the injuries sustained by the rest of the victims are all simple in nature. Stop. It further appears that there has been a dispute between the two fractions. Correct?
Yes. Respect of certain land.
In respect of land. Stop. It further appears that the investigation has progressed substantially and the statements of witnesses have already been recorded. Stop. As such, this court finds that custodial interrogation of the petitioners may not be required in the interest of the ongoing investigation into the case. Stop. Further, there are no adverse materials available on record as regards the antecedent of the petitioners. Ready? Accordingly, the interim pre-arrest bail granted by VD order dated 21/2/2024 is hereby made absolute, subject to the following conditions. Stop. Semicolon diva. 1 and 2 didia. Number 1, cooperate with the investigation. Number 2, inducement. Return the case diary. This disposes of the anticipatory bail application.
Obliged.
TD not received.
Not received. Await TD. Are you on interim?
No, Lordship. No.
LCR?
Yes, Lord. This is a bit different case, Lordship. In this case, someone has been issued to us, and the section being session triable, I'm apprehending arrest and detention by the court.
No. In this case, item 40, LCR along with case diary was called. That has not come.
Yes, Lord.
So we'll send a reminder. Let a reminder be issued through the registry for the scanned copy of the LCR along with the case diary from where? From the court of CJM Dhubri. List this matter after 1 week on a date fixed by the registry.
Date may be fixed, Lordship. Otherwise, there's some problem.
Date did you go for?
15?
15?
18.
Okay.
Obliged, Lord.
Yes.
I please, Your Lordship. 430 application, my lord. In this case, my lord, FIR
Is there
Receive, my lord. FIR was lost by the elder brother of the LS victim, my lord. Now, the LS victim is the legally married wife of the petitioner number 1, my lord.
Mm-hmm.
My lord, they got married, my lord.
Oh, they got married?
Yes, my lord. They have been residing at the same household, my lord. Now, my lord.
FIR was lodged by?
Lodged by the elder brother of the LS victim, my lord.
Elder brother of victim.
Yes, my lord.
And then?
Then thereafter, my lord, on 23/1/2024, my lord.
23?
23/1/2024.
Yes.
On that very day, my lord, there was some discussion.
And they got married.
Regarding the marriage of the LS victim girl, my lord.
So now victim is married to whom?
Yes, my petitioner number 1, my lord.
To the elder brother?
No, my lord.
To the present petitioner.
Present petitioner, my lord. Petitioner number 1, my lord. There are 2 petitioners, my lord. Petitioner number 1 is the...
Okay, FIR?
FIR page, my lord. Page 10, my lord. Particular. Page 10, my lord.
Yes.
Yes.
Where is the translated copy?
Translated copy, my lord, at page 8, my lord.
8, my lord.
Yes. So they've already married.
My lord, yes, but one thing is that, my lord, she gave a statement in 164. On that day, she has not completed 18 years, but 5 days to
But my lord,
She herself stated in 164 that she eloped with the petitioner, my lord, on 23/1/24, but as regarding her marriage, some discussions were going on with some other. She is in love with this person. And on 27/1, when she got 18 years,
she's a major and she is already married.
Yes, now married.
To this person itself. Yes. Then what remains?
And petition
Were
number
you on
2 is the
interim
father.
earlier? No.
Petition number 2 is the father-in-law, my lord.
Were you on interim earlier?
No, my lord, no.
61. Heard Mr. S. Ahmed. Yes. Heard Mr. S. Ahmed, learned counsel for the petitioner. Top also heard Mr. K.K. Parashar, learned APPs for the state respondent. This is an application under section 438 of the Code of Civil Procedure 1973 for granting pre-arrest bail to the petitioners. Number 1, BASER, Qasar Mia, and number 2, Kazibar Mia, who are apprehending arrest in connection with Manikpur PS case number 12/2024, registered under section 366 IPC. Stop. The facts of the case of the prosecution is that who is the informant?
Elder brother of the Sofijur Rahman.
The case of the prosecution is that the informant on 25/1/2024 lodged an FIR alleging that on 23/1/2024 the FIR mentioned accused persons, namely being the present petitioner herein, eloped his younger sister from their house without their knowledge and kept her concealed in their house. Stop. Accordingly, a case was registered. Stop. Mr. Ahmed, learned counsel for the petitioner, submits that in the meantime, the victim, Nalbhanu Khatun, has husband who is a major, has married the petitioner number 1. Stop. Mr. K.A. Parashar, learned APP.
On that date, she was not major. She is.
Anything else?
Other, now, already married. As per 164 statement.
Submits on the basis of the statement of the victim recorded under section 164 the RPC that she admits that she was in love with the petitioner number 1 and accordingly had gone with him since her family was trying to get her married to someone else. Stop. She further admits in her aforesaid statement that now she is married to the petitioner number 1 with petitioner number 1. Stop. Then you say, considering the facts and circumstances of the case, comma, it is provided that in the event of arrest, comma, the petitioners named above shall be released on pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 15,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following condition. Number 1, investigating officer, and number 2, conditions required, settlement already arrived. Anyway, number 2, directly inducement. All right.
They may come for quashing then.
And return the case diary and with the aforesaid observation and direction, this anticipatory bail application stands disposed.
Much obliged, Lordship. Obliged.
Fresh step, petitioner absent. None appears for the petitioner when the matter is called. List this matter after 4 weeks on a date to be fixed by the registry. Yes. R2. Service completed. Is there a judicial order accepting the as regards the completion of service? It appears from the office note dated 29/1/19 that the AT card in respect of respondent number 2 has been received back after due service. Stop. And accordingly, service in respect of respondent number 2 stands completed. Stop. None, don't say anything. Then list after 2 weeks. List after 2 weeks.
Admission column.
In the list after 2 weeks on a date to be fixed by the registrar.
Earlier interim order.
Interim order, if any, shall continue till then.
Okay.
Await service report in respect of the sole respondent. Stop. List this matter after 4 weeks on a date to be fixed by the registry. Interim, if any, shall continue till then. Yes.
By mistake of the clerk, steps was not taken to the respondent number 1. So I may be allowed to take this step
on
respondent number
2 or 1. Your name?
A.L. Mandal.
Mr. A.L. Mandal, Learned Counsel for the petitioner, submits that he may be allowed to take fresh steps in respect of respondent number 1. Stop. Prayer allowed. List this. Prayer allowed. Let fresh steps by registered post be with AD be taken on in respect of respondent number 2. Stop. List this. 1.
Proceed. Legal.
Why? List this matter after 2 weeks on a date to be fixed by the registry. This is a POXO matter. Oh, the respondent.
Against the acquittal.
Respondent number 1 is the victim.
Yeah. No, accused.
Accused. Yes. Sorry, OP. You please kindly cancel this order. POXO matter. Steps on the respondent number 2. 2. Stop. Prayer is allowed. List after 2 weeks on a date to be fixed by the registrar. That matter which you were trying to mention in the morning. Yes. So, notice is not done.
Completed, Lord.
Notice is completed. But anybody appearing for R2? No. R2, who is R2?
The informant.
The informant.
Amicus curiae need to be done. Amicus curiae.
No, but
if none.
Amicus curiae is required because what if the informant engages anyone? Notice is completed.
Then it may take time. Then the next date not. Fix another.
No, because why I am saying, Mr. Das, that Deepak Nayak case you are aware of, right? So that says that in all these matters, notices has to be served on the victim, either through yes. So you are otherwise there in the panel of legal aid counsel. So in that earlier case, instead of saying amicus curiae, should we say as legal aid counsel, and we can appoint? That would be more appropriate because I think for amicus also there is a panel. Are you there in that list? But in this list you are there. You mean OP where I said in earlier case, you say as legal aid counsel. Appointed as legal aid counsel. Okay? Yes.
In this case, appellant behind the bars more than 475 days, Lordship. Only 5 years jail.
So why is it for orders today?
Lordship, earlier, my friend.
Yes, Mr. Chaudhary? Have you received?
Yes.
Then we fix this for hearing.
Lordship, bail may be granted. Lordship, with respect
No,
to-
what bail will be granted at the hearing stage? We are fixing it for hearing next week. It is Mr. U. Chaudhary, Learned Legal Aid Counsel, appearing on behalf of respondent number 2, submits that he has received the necessary documents in the matter. Stop. Let this matter be fixed for hearing on
Short date will-
date. Give a date.
Any date, Lordship.
Lordship, he behind the work, Lordship, more than 15 months, Lordship. And this month, right?
9th April.
Lordship, short date may be given, Lordship. More than 15 months, Lordship.
Bihura got video attack.
More than 475.
All right.
3 or 4 April.
Hearing?
Oblast.
Photocopy.
It's
Yes.
dated 4/3/2024.
LCR?
LCR also not received.
Service report, what about?
Service report is also awaited.
Awaited?
Awaited. Office noted 4/3/2024.
Yes. It appears from the office note dated 4/3/2024 that service report in respect of R2 is still awaiting. Stop. Further, it appears that the scanned copy of the case diary of the LCR along with case diary is also awaiting. Stop. Reminder already sent.
Reminder already sent.
So let this matter be listed again on April.
Lordship. Second April.
2nd April.
2/4/2020. Yes, why is it for orders?
Lordship, study response number refused. Number 3, not unserved and LCR received.
R2 not completed.
Refused.
No, R3 refused. R2 not completed.
Yes.
Await service report in respect of respondent number 2. Stop. LCR received.
Yes,
It appears that the scanned copies of the LCR along with case diary has been received. Stop. Retain the same. List this matter after 2 weeks on a date to be fixed by the registry.
That's all right.
Yes, Mr. Chaudhary.
My lord, there is a delay in preferring this.
20 days. 20 days.
28 days.
28
Only
days.
thing, my lord, this is a maintenance matter, my lord.
So notice has to go.
No, my lord, already notice was sent, my lord. We have taken steps. But wife has, my lord, as per the, my lord, office note dated 4/3.
Address the outstation.
No, my lord. Thereafter another is there, my lord. She has refused to, my lord, as per the postal report. 4/3/2024.
Yes. Can we condone the delay?
My lord. This is, my lord, regarding maintenance, my lord.
No, no, this IA is for what?
For condonation of this.
Correct. So let us first pass the order in the IA.
My lord.
And then the criminal revision is for...
That has to be numbered by...
Let that be... Yes. You're right. Heard Mr. B.M. Chaudhary, Learned Counsel for the petitioner, Learned Counsel for the applicant.
My lord, petitioner, my lord, revision petition.
So in the interlocutory application?
Interlocutory petition.
This order is going to be passed in the IA, right?
My lord.
OP IA Criminal 125. So there you're the applicant.
Yes, my lord. But I have so written as petitioner.
Why? Is this not an interlocutory application? Anyway, petitioner doesn't make difference. So for petitioner, stop. Also heard nobody is the other side. No, government, are you there in this matter?
Maintenance matter, my lord, we have not met state as a party.
If not, It appears from the office note dated 4/3/2024 that the sole respondent has refused to accept the notice issued by this court. Now, next. This is an application under Section 5 of the Limitation Act 1963 by the applicant for praying condonation of delay of 28 days in filing the criminal revision petition against order dated 14/8/2023 passed in FC criminal number 589/2022 by the learned principal judge, Family Court -2, Guwahati. The case of the petitioner is that the petitioner was prevented to file the connected criminal revision petition within the stipulated time. So, for reasons beyond the control of the petitioner. So, I have heard the submission. I've heard the submission made on behalf of the applicant and also have perused the application for condonation of delays. So, it appears from paragraph 2 and 3 of the aforesaid petition that the petitioner was prevented from filing the revision petition within the stipulated time due to certain misunderstandings between the petitioner and the respondent in connection with the attempts to reconcile the matter. So, it is only after all attempts for reconciliation failed, the petitioner had filed the connected revision petition. However, pending such reconciliation, the period of limitation expired. Stop. Next para. In view of the aforesaid explanation, this court is of the considered view that the delay of 28 days occurred in filing the criminal revision petition ought to be condoned in the interest of justice. Now, accordingly, delay condoned, application allowed. In the criminal registry is directed to register and number the connected criminal revision and list the same if
after a week, because that case is pending in the family judges.
When do you want it?
After a week or 10 days, as you
after a week, on a date to be fixed by the registry.
I'm obliged, Lord.
Disposed of. Huh? I is disposed.
Yes. Possible find page 37 is the improved order.
What is the status report regarding the Mahindra Scorpio vehicle?
But it was seized on 12/10/2023.
Yes, Mr. Das.
We have not received.
Awaiting.
We have not received from the IO.
When can you have it? Sufficient time has gone. Give a firm date.
On Lordship 12.
And you ensure by then it arrives. Await service report regarding vehicle bearing registration number ML08C4757. No. List this matter on 12/3/2024.
Attempt on that day, the attempt may be made.
Next. Yes.
We have taken the step, my lord, few days back, my lord. We have
Await service report.
Yes,
await service report in respect of
2 and 3.
In respect of respondent number 2 and 3. List after 2 weeks on a date to be fixed by the registrar.
Much obliged.
Yes.
Lordship, this is my second application under section 389.
Yes.
Seeking bail, my lord.
389.
Yes.
Suspension of sentence.
Dear lord.
Second time.
Second time. Petitioner and the bar, my lord. For,
Informant is there.
8 months.
Informant is there.
8 months, 3 days. Bail, my lord. And earlier, my lord, the order, my lord, that is 46, my lord. And passed by, my lord. Case 46, my lord, earlier reject order.
Okay, then it has to go before that code, I think.
But, lord, I, my lord,
Mr. Das?
389.
My lord, yes.
Isn't it now the circular says, I think?
No, this is not my lord, regular bill. This is bill relating to my lord.
Correct, but
Your lordship can. Because these matters are being taken up by your lordship.
No, that's right. But a notification খন আছে নেকি নাই? কিন্তু সেইখনত অকল বেল কৈছে.
That is regarding bail. Once this is
এইটোত তেওঁলোকে suspension, but
suspension and bail is also there.
And bail is there. That is why I am saying.
But perhaps that may not be an impediment in.
We don't have that notification in front right now. So, if I recollect, bail is mentioned. You see, though you are saying suspend the sentence, but at the end of the day, you are also seeking for bail. Correct. That is why it appears that it appears that this court has earlier, by order dated 28/11/2023, rejected
application under section 389.
Rejected the prayer for grant of bail while dealing with the application under section 389 of CRPC. Stop. Registry to verify and list this matter before appropriate bench. Stop. Okay. Registry will do it immediately on priority basis. Okay. 54 also same. No.
Right, please, Your Lordship.
OXO.
Oh, Lordship, this matter relates to under section 125, Lordship. 125 CRPC maintenance.
54.
Yes. Regarding item number 54, this IA criminal is for extension to appear before the family court of the applicant. Lordship.
No, what is the IA for?
IA is for extension of the period to appear before the family court. Lordship, we have para 3 of the IA, page number 3.
Yes.
We have mentioned that we couldn't, it is for advocate for the petitioner forgot to inform the applicant.
Okay, and then what happened? Where is the order?
Order at page number 6.
This order is passed by Justice Parthiv Jyoti Soike. You want a modification of this order?
No, Lordship, for extension.
That amounts to modification.
Yes, then it has to go before that bench, isn't it? Number 3. By filing this application, the petitioner is seeking modification of the order dated 9/1/2024. Stop. Registry to verify and list it before the appropriate bench.
Let them have a copy.
They have not given you a copy. Why?
Lordship, we will have a copy.
Do I have a copy? A copy of the application be served on respondent number?
Sole respondent.
On the sole respondent. On the learned counsel appearing for the sole respondent. No. Okay. Await service report in respect of respondent number 2. Stop. List the matter after 2 weeks on a date to be fixed by the registrar.
Obliged. An application for continuation of delay of 111 days, my lord, in the connected appeal, my lord.
111.
Yes, lordship. And we taken a step for service of notice upon the respondent number 2. And as per office note dated, my lord, 5/3/2024. No, notice.
No, not found. RTS.
Yes, lord.
Yes.
Says I may pay for continuation of delay, my lord.
No, but the envelope says not found. How can we ignore that you... Who is the R2?
R2 is an informant, my lord. Informant victim, my lord. Informant victim, lord.
This is POXO.
Oh, my lord. He was convicted under section, my lord.
Uh-huh.
He has mentioned the offense not
Convicted. My lord, convicted.
Well, Mr. Das,
Under section 366. my
did
lord.
we say that notice to the jurisdictional police station?
My lord, regarding so far, my lord, regular appeal is concerned, my lord, we do not object normally, my lord, because that is a my lord, statutory right to appeal. My lord. So we concede normally. But the offense to keep. Delay may be controlled, my lord.
All right. Heard Mr. P.D. Nair.
H. Rahman.
Heard Mr. H. Rahman, learned counsel for the petitioner. Stop. Also, you are there? State is there?
Yes. It is.
Also heard Mr. P. Das, learned APP or state respondent. Stop. It appears from the office note dated 5/3/2024 that service in respect of respondent number 2, informant.
Yes, sir.
Informant was returned with the endorsement within court, not found RTS.
Sorry.
Stop. This is an application for condonation of delay of
111 days.
111 days in filing the connected criminal appeal against the judgment and order dated 31/5/2023 passed by the learned additional session judge Sipsagar in sessions case number 195 within bracket ///2012. Stop. The case of the petitioner is that paragraph 4 A, B, C, D, E. My flag code is so. I like us. Down to it will be. Where is the flag log ID? It appears from the aforesaid arguments made in the condonation application that the petitioner has sufficient cause and the delay sufficient cause. Stop. As such, the delay is condoned. Stop. Registry is directed to register
the appeal.
To register the connected criminal appeal and place it before this court. Stop.
For admission. It will
For
come for
admission.
admission.
IA disposed of.
Appeal may be likely to be listed after a lot.
Huh?
Can't pay for listing it after a week.
No. Will come. We can pray later. Let it get first registered.
Yes, sir.
20.
Wait, please, Lord.
Yes, Mr. Surajit.
My Lord, 239 application.
29.
Yes. My Lord, FIR is at page number 12. Let me remember this matter. Initially, my Lord, they were all on interim, my Lord. Mainly,
Yes.
and after perusal of the CD as well as the photograph of the victim,
That brick.
Lordship.
Oh. Again you have come.
Yes, I am accused number 5. That time I was the different man. This time I was the accused number 5. No direct allegation as such. Let me kindly see the FIR. Accused number 12.
Yes, Mr. Das?
Yes, Lordship.
This is regular bail, man. I have already surrendered after that.
This is first time today?
No.
No, no.
No, already case diary was called for.
Yes. Cesari, you have received? Yes. What about his involvement?
His involvement is that, Lordship. There are many more persons. However, the petitioner number, accused number, Lordship.
Who are you, Mr. Das?
Accused number 5, my lord.
Anarul Aslam?
Yes.
Yes.
13, my lord, page number 13.
Yes.
My lord, the direct specific allegation against the accused number 5 is that accused number 5 even issued a death threat, physically assaulting him by pushing him into the bricks, causing severe injury.
Where are you reading from?
Yes, my lord, the FI page number 13, my lord.
Yes, but which part?
Middle, my lord.
Yes.
I may read the entire FI, my lord.
No, just say that.
Yes.
You are involved.
But my lord, the thing is that, my lord, the actual victim who suffered big injury, my lord, was caused by
Before is there.
Accused number 1. Accused number 1, while accused number 2 and 3 were restraining him, accused number 1 struck the victim with a brick. My allegation is different. My allegation is against the father of the informant, my lord. He did not sustain any grievous injury. He simply sustained simple injury.
Where?
That is it, my lord.
Accused 5, right?
Yes. Around 13th.
Accused 5 even issued a death threat.
Yes.
Physically assaulting him. Him means who?
The father of the victim.
By pushing him into the bricks, causing severe injuries to his chest and body.
Yes. Witnessing this, my brother Asadur Rahman arrived. While picking up my father, accused number 4, all accused number 1 and accused number 1, Rana Farooq, arrived on a Pulsar motorcycle, shouting Dhor Dhor, accused number 2 and 3.
Do you have the injury report of the father? That's not there.
I have the injury report of this
brother,
Asadur Rahman.
Of brother. No, because father's injury report would indicate, because here it says issued a death threat, physically assaulting. You see, assault is there. By pushing him into the bricks. Even the bricks, we don't know what sort of injury. Causing severe injuries to his chest and body. The allegation is there.
But injury report will be called for, man.
However, Lordship, if I look into it, Lordship, the brother,
in
his statement, this person's name is there.
Saying what?
Accused person name.
Saying what?
Actually, what happens, Lordship, is this person, brother, Rana, accused number 1, Rana Farooq Ahmed. He first hit the accused victim with a brick, Lordship. He fell down, and after he fell down, all these persons, this person is also there, Lordship. They hit him and kick him in the chest, Lordship. Moreover, it is also stated that with a brick, they have beat him. However, in the victim statement, he have not stated that in the head, but on the other parts of the body. But one of the witnesses there, he has stated that also hit him on the head, Lordship. One of the witnesses.
About this person. So there are evidences showing that the petitioner has hit the victim. The brother or father?
Brother.
Brother in his head.
As per the one of the witness, Lordship.
Where is our order? You annexed it, my order?
Yes.
Where?
At page number 21. Even para is at page number 8.
This is what? This is a bail.
Anticipatory bail.
AB.
AB. That was AB.
And this?
439. Regular.
How many days?
36 days. After this, my lord, he has himself surrendered before he put this. My lord, the only question which he further detained for the purpose of
We can do one thing. We can ask. We can ask you to have the injury report of the father. Have it. Then we can consider the entire matter. Whether
specific name may be there, Lordship. Injury report on the order.
Yes. It appears that the allegation against the petitioner is that he has physically assaulted Mofidul Islam, i.e. father of the informant, by pushing him into the bricks and caused severe injuries to his chest and body. However, the injury report as regards Mofidul Islam is not available in the case diary produced before this court. Let the injury report injury report of Mofidul Islam be produced on the next date. List on
15, Lordship.
15/3/2024.
Highly obliged.